This matter is appearing under the heading extension of interim order upon being mentioned therefore, full stop. Affidavit in opposition has already been filed on behalf of the respondent numbers 1 to 4, full stop. The petitioner has not yet filed his affidavit in reply, full stop. It is submitted by Mr. Dugar, learned advocate, appearing for the petitioner that reply could not be filed. Okay. It is submitted by Mr. Dugar, learned advocate, appearing for the petitioner that affidavit in reply to the affidavit in opposition could not be filed inasmuch as the same has been served only today. Full stop. In such view of the matter, let affidavit in reply to the affidavit in opposition filed on behalf of the respondent numbers 1 to 4, comma, be filed within 4 weeks from date. Full stop. The interim order, the subsisting interim order, which is to continue till the end of December 2025, is extended till the end of February 2026. List this matter for hearing in the monthly list of February 2026. এটা রেখে দিন।
Item number 4.
Affidavit has been filed. My affidavit has been filed.
Lordship, I'm appealing for the petitioner.
Yes.
Lordship, earlier at the time of mentioning, 3 of the matters altogether were mentioned, but unfortunately,
Why has this been mentioned for extension of interim order? Yes.
Today, Lordship, one of the matters is appearing in this list and the
So
other.
very well, the other will appear on other day. For this, you make your submission.
I'm praying for an extension of the interim order today.
Very well. You have filed your reply to the affidavit in opposition. Why haven't you filed?
Lordship, I kindly allow some time to find.
No, you are enjoying an interim order. You should have filed your reply. You are the petitioner.
It has
I will limit the interim order only till January. File your reply. It can't go on like this. What is the challenge in the writ petition?
recovery notice is being issued. So it has been
The
challenged.
recovery notice is not the subject matter of challenge. What will be the subject matter of challenge?
The IPC, we are claiming the IPC.
Very well, you get ready.
Appellate authority.
This matter
Appellate authority
has been challenged. Now, this matter has been listed under the heading OISEM, extension of interim order upon being mentioned therefore. Full stop. Learned advocate appearing for the petitioner submits that some more time is required for filing affidavit reply to the affidavit in opposition filed on behalf of the respondents. Full stop. Let affidavit in reply to the affidavit in opposition filed by respondents, comma, be filed within within 1 week after reopening of this court after the Christmas vacations. Full stop. The interim order, which is to continue till the end of December, 2025 is extended till the end of January 2026. List this matter for hearing immediately after expiry of the time fixed for filing affidavit in reply.
Number 5.
I'm appearing for the interim order is expiring in December 2025, my lord. We have paid 20% of the tax in dispute in terms of the order passed by this honorable tribunal on 18th December 2020. Affidavit in reply has not been filed, my lord. Because my clerk, my lord.
I'm limiting it. That is not going to cut ice because every time it has been extended only. Has never been made absolute. Your reply is also not ready. So you can't have best of both the worlds.
Kindly consider, my lord. I will file,
Same,
my lord.
same name. Will be unfair. You are in default, then I will extend interim order until further order. Can't be that.
Yesterday, same petitioner's case appeared, my lord.
Very well.
Both the
Yesterday I have
affidavits proposed, my
committed a
lord,
mistake that does
even
not mean
even
that
by them, my lord, I was misplaced, my lord. Your lordship extended, my lord. Kindly consider.
please don't press, Mr. Duga. I won't do that. Yesterday is gone. Today is a
Yes.
fresh day. Tomorrow will be another day. Same. This matter is appearing under the heading extension of interim order upon being mentioned therefore. Mr. Dugar, learned advocate appearing for the petitioner. Seeks extension of time for filing affidavit in reply to the affidavit in opposition filed on behalf of the respondents. Full stop. Let affidavit in reply to the affidavit in opposition be filed within 1 week after reopening of the court after the Christmas vacations. Full stop. The subsisting interim order, which is to continue till the end of December 2025, is extended till the end of January 2026. List this matter for hearing immediately after expiry of the time fixed for filing affidavit in reply. Next.
Fine.
My lord, I am for the petitioner. The interim order is expiring on 19th.
So I appear for the respondent bank, because the interim order cannot be extended today because there is a 95 proceedings pending before the NCLT against the petitioner.
Lordship, the petition has been preferred by the individuals.
So 95 has
Petition.
been filed. No court can pass any order against the
No, Lordship, the petition has been preferred by the individuals.
When was it filed?
95. Lordship, kindly please say. But it was filed in 1st March 24.
So
4th March.
even then it has been extended. You were
Lord,
present.
I was not aware of.
You were
Tata,
present.
no, Tata Capital had
Lordship, the interim order.
It has been extended once by the court and it is continuing. Why should I injunct
no,
now?
but the Tata Capital has filed.
21st of August 2025 interim order has been
I
extended.
understand.
So
We
after
were,
that interim order has
we
continued.
were not aware of.
That makes little difference because if after this order has been passed, this court has extended, that cannot be a ground now to not extend.
I am not on. Kindly, my lord, here's the matter then.
Hear it
There-
today.
I am ready.
Say
Lordship, I am being led by Mr. Shuddhasatya Banerjee.
They
He is
are
not informed.
relying upon an addendum with regard the fraud.
Mr. Pramanik, don't press like this because
I leave it.
appearing for extension of
I
interim
leave it
order
to you.
unnecessarily you are opposing. On August 2025 we did not oppose.
You know, I had opposed because
Nothing
95.
is there.
I leave it to Lordship.
This matter is appearing under the heading of extension of interim order upon being mentioned therefore. Full stop. Having heard the learned counsel appearing for the respective parties, the interim order which is subsisting and is to continue till the end of December 2025 is extended till the end of January 2026. List this matter for hearing in the combined monthly list of January 2026.
The difficulty
Great.
is whenever this matter is being taken up, they prefer for time.
No, Lordship, only on one
Ensure
occasion
that.
we have
What is
prayed.
the matter about?
Fraud. Declaration of the account as fraud. They had, my lord, challenged the addendum that was never supplied to them. That is the only ground taken in this writ petition. Addendum prepared by the resolution professional. Whether that is required to be looked into by your lordship, that is the only issue. The fraud account has been classified as fraud. Now he wants to get this matter somehow.
Lordship, on the ground of not supplying of addendum, we were given a stay order. My learned friend had taken out an affidavit in opposition. They have not mentioned whether they have served me the addendum or not. That
No,
point
but-
has not
but-
been mentioned.
Does the addendum form the basis of the order?
Yes,
declaring-
admittedly.
Addendum we have not served. It is for the RP to say whether the addendum has been served or not. It is for the
No,
lead
does
bank.
that form does that form the basis of your order declaring the account as fraud?
Admittedly, Lordship.
Then in that case, that ought to have been served.
That we cannot say. We are, my lord, the RP.
If you have relied on it, you have relied on it for
Yes,
the
we
purpose
have.
of declaring
We have.
it.
Whether it has been
So
served,
that is the material relied on you,
Lordship.
relied on by you.
lordship.
You could have served it, even if the RP had not served. because
Very well,
you are
Lordship.
relying on that material.
Lordship will kindly hear it at any day, subject to my lord's
Very well, we'll
convenience.
hear it.
My lord, no,
Didi, ওটা January te monthly list, it is coming in the monthly
Well,
list. You please mention.
okay.
You mention, I'll upgrade
Okay,
it.
lordship. I'm good.
I'm grateful.
Because these matters shouldn't wait.
I
One way or the other, it should be decided.
Grateful.
Item number
Item
Item number 7, my lord. I am praying for extension of interim order, my lord. They are expiring on 31st December. And it-
Affidavits are complete.
No, my lord. In this matter, my lord,
No, affidavits are not ready.
not,
I need to- or I'm praying for some time to file my affidavit in opposition.
this is challenge of 168A notification.
Oh. This matter has been mentioned. This matter is appearing under the heading extension of interim orders upon being mentioned therefore, full stop. Heard learned advocates appearing for the respective parties. Na, tar aage likhun. Mr. De, learned advocate appearing for the respondent CGST authorities seeks extension of time to file affidavit in opposition to the writ petition, full stop. Let such affidavit in opposition be filed within 4 weeks from date, full stop. Affidavit in reply to such affidavit in opposition, comma, if any, comma, be filed by the petitioner within 2 weeks thereafter, full stop. List this matter for hearing in the combined monthly list of February 2026, full stop. The interim order, the subsisting interim order, which is to continue till the end of December 2025, shall stand extended till the end of February 2026.
I'm grateful.
The item number 8 also relates to 168A, but my lord, in the original order, my lord had appeared.
Oh. This matter stands released from this list on my personal grounds. List this matter before the Honorable the Acting Chief Justice for appropriate order.
Now, one more thing, if my lord will allow me to mention, but at this stage, in item number 1 and 2, the can is already there in the court, my lord. Can 1 and 2. We just had it checked with the court officer. Can 1 and 2 is already there. If my lord will kindly take it after the interim orders list is finished.
Very well. Then I'll take it. The other side is there.
My lord, Kunjali is there.
Yes,
I am grateful, man.
we'll take it. Didi 1 and 2 এর অর্ডারটা হবে না কেন পাওয়া গেছে তাহলে করে দিই
Well, I am praying for extension of the interim order, my lord, expiring in December. My lord, what happened in this case, my lord? Department has to take the instruction, my lord, my learned friend has to take the instruction as to whether the tax has been paid by the supplier or not. That was the only ground for disallowance of the claim of ITC, my lord. So if my learned friend has taken the instruction, my lord,
On
matter can
January,
be
if
taken,
your
my lord, kindly fix
lordship
it.
Kindly fix it on January, we will, instructions.
Matter will be
there.
resolved.
We'll
Very
argue
well.
the main point, your lordship.
This matter is appearing under the heading extension of interim order upon being mentioned therefore, full stop, paragraph. Heard learned advocates appearing for the respective parties, full stop. The subsisting interim order is extended till the end of January 2026, full stop. List this matter under the heading motion in the combined monthly list of January 2026.
And in that
When
case,
it for upgradation, I'll upgrade it. Because today I cannot direct
Yes,
it
yes,
to appear as
yes.
urgent motion.
I understand. I'm good.
1 and 2 টা call করে দিচ্ছি শেষ তো।
তখন বাস করি।
Look, can to the prayer portion, my lord, first half of the prayer may be allowed. Second half, my lord, pre-deposit may, my lord, I'm not pressing there.
ক্যানটা দিন এই প্রথমটা
The prayer doesn't say without pre-deposit.
My lord, the second half without insisting of pre-deposit of 7.5%. Last two lines. Look, can two, my lord, is looking at
Can 2,
can two
Page five.
page 13, my lord.
can 2, 7675.
My lord. My lord, the prayer A,
Okay.
internal page 13.
Yes, without insisting.
So, my lord, the top portion, the first half.
And in can 1, that
So,
prayer
the can one is a refund issue, so there is no question of any pre-deposit. The second matter, my lord, the appellate authority is the Commissioner Appeals, and first matter 768 is CESTAT.
যদি লিখে নি ওই এটা 7675 এর হ্যাঁ can 1 can 2 2025 is an application seeking an order seeking the following order inverted comma এই prayer এটা কোট করি since the petitioners paragraph B, since the petitioner or petitioners
Petitioners.
since the petitioner is desirous of availing the alternative remedy of appeal before the CESTAT, before the appellate tribunal, i.e. CESTAT, upon withdrawing the present writ petition, comma, this court is of the view that the petitioner's prayer should be allowed to that extent, full stop. However, comma, insofar as the petitioner's prayer to allow the petitioner to approach the appellate tribunal and get its petitioners and get their appeal heard without insisting, inverted comma, without insisting upon pre-deposit of 7.5% of the impugned demand for service tax, comma, in view of the exceptional facts and circumstances of the present case, inverted comma closed, comma. This court is not minded to grant such relief in the present case. Full stop. Should I give reasons or?
No, madam, the only thing I'm saying that give me some time to deposit. Like 3 months time to deposit, because maximum amount of 10 crores. The law provides the maximum and I am coming in that category. Give me 3 months to deposit. I'll file the appeal in 2 weeks time.
Full stop. Paragraph. Mr. Bagadia, learned advocate appearing for the petitioner, submit that the petitioner would be able to meet the statutory pre-deposit condition if 3 months time is granted to the petitioner. Full stop. In such view of the matter, this court deems it fit to allow the petitioner that opportunity. Petitioners that opportunity. The petitioner shall be entitled to file appeal before the appellate tribunal upon withdrawing this writ petition. However, such appeal shall be entertained by the appellate tribunal upon the petitioner complying with the condition of pre-deposit within 3 months from the date of this order. Full stop. If such pre-deposit is made, comma, the appellate tribunal shall consider the petitioner's appeal and dispose of the same in accordance with law.
I'll file the appeal within 2 weeks.
My lord, makes it clear that my lord has not gone into the matter.
Yes, it is clarified that it's
But I will kindly make it clear, because in the tribunal.
as requested by the parties, it is clarified that this court has not gone. I'm allowing it to be withdrawn. It makes no sense.
No, because my lord has given a direction of rejection of that
Prayer for
prayer
pre-deposit.
A.
So if he withdraws, I'll not give that direction, that prayer.
But it only is clarificatory. This
As requested for by the parties, it is clarified that this court has not gone into the merits of the case, and all points are left open to be decided before to be urged before Sestat and be decided by Sestat, comma, in accordance with law.
appeal filing is within 2 weeks.
अच्छा, लिख लीजिए. Mr. Bagadia's submission, if I Mr. Bagadia submits that his clients, that the petitioners shall file the appeal within 2 weeks, but shall be able to meet the condition of pre-deposit, statutory pre-deposit, within 3 months. Correct. I'll appropriately incorporate.
I'm good.
No, it should not be a situation where appeal is heard first and the 3-month period.
No, I have said
No,
that
my
the
lord,
appeal will be heard only after the pre-deposit. I have said
My lord, kindly that affidavit in opposition has been.
affidavit in opposition filed on behalf of the respondent numbers 3, 4, and 5 is taken on record. Should I record this? You say that you are out of pocket and all, then I'll have to give reasons
No, my lord.
why.
Because I am now undertaking to pay the pre-deposit, so tribunal does not have the power to.
Then I'm recording that you are not pressing that prayer for pre-deposit, you are only seeking extension of time. That will be better.
Better.
My lord.
Acha.
There are all instructions.
On instructions, of course. এই আগেরটা কেটে দেবেন ওই প্রেয়ারের পরে যেটা লেখা আছে প্রেয়ারটা কোট করলেন তারপরে এই প্রেয়ারটা কোট করলেন তারপর থেকে এবার যেটা বলছি সেটা লিখুন Mr. Bagadia, comma, learned advocate appearing for the petitioners, comma, on instructions submits that he is not insisting, he is not pressing, the petitioners are not pressing the prayer for hearing out the appeal, for Sestat hearing out the appeal without insisting upon pre-deposit of 7.5% of the impugned demand. Full stop. He, however, submits that the petitioners would be in a position to meet the condition of statutory pre-deposit provided 3 months time is given to them. Full stop. In such view of the matter, he further submits that the petitioners would file the appeal within 2 weeks from date. Full stop. In such view of the matter, this writ petition is permitted to be withdrawn. Full stop. The petitioner shall be entitled to file appeal within 2 weeks from date. Full stop. This court deems it fit to allow the petitioner opportunity to meet the statutory pre-deposit within a period of 3 months from date. Full stop. Testat shall proceed to hear the petitioner's appeal only upon the condition of pre-deposit being met by the petitioner within the time specified herein above, within brackets, i.e. 3 months from date. Full stop. As requested by the parties, it is clarified that this court has not gone into the merits of this case, and all points are left open to be urged before Sestat and be decided by the Sestat in accordance with. That takes care of it.
Item number 2.
I said I'll let you.
So far as item number 2 is concerned,
Here the appellate authority is the Commissioner Appeals, and question of pre-deposit does not
Doesn't
because
arise.
my refund application. And
Very-
now there are 3 orders in original, so I have to file 3 appeals.
very well.
Simplicity of
এবার
withdrawal.
WPA 11075 এটা লিখবে। Affidavit in opposition দুটোতেই থাকছে। Can 1 আচ্ছা, তার উপরে এই উপরের অর্ডারে একটা লিখে দিন দিদি। WPA 7675 of 2020 thus stands dismissed as withdrawn with liberty to the petitioner to file appeal within 2 weeks and meet with the statutory pre-deposit condition within 3 months from date as indicated herein above. Full stop. Can 1, Can 2 of 2025 stands disposed of accordingly.
And the writ petition.
The writ petition is dismissed as withdrawn, not disposed of. Can 2 is disposed of accordingly. No costs. তারপরে নিচেরটা ওই WPA 11075 তাতে লিখুন Can 1 না Can 2 না
Can 1. Can 1 of 25.
This is the simplicity
Can 1 of 2025
So this is simplicity of withdrawal with leave to file appeal.
সব এমন ভাবে
Can 1 internal page 5.
Yes. Can 1 of 2025 is an application seeking withdrawal of WPA 11075 of 2021
I'm grateful, my lord.
যেটা বললাম, কারণ আমাদের not press করলে।
Your lordship,
Yes,
your lordship serial. Well, I'm
Mr. Bagadia, so I have recorded, you are not pressing that prayer of
My
statutory
lord.
deposit, and
My lord, my lord,
I have not dealt with them.
my lord, absolutely. I'm grateful.
কি করতে হবে?
Well, I'm for the respondent, my lord. Well, though there was a direction for extension of time to file opposition, my lord, we have prepared but could not, my lord, file the, my lord, opposition is ready, my lord, but could not affirm it, my lord, some extension may be given.
But this is for extension of interim order. This has come under the wrong
Wrongly
heading.
come under the heading, yes.
The interim order may be.
I'm
My lord.
extending the interim order. Third learned advocate, na, দেখুন Mr. Bhattacharya, learned advocate appearing for the respondent CGST authority. CGST authority seeks further time to file affidavit in reply
Opposition, my lord.
of affidavit in opposition to the writ petition, full stop. As requested, comma, let affidavit in opposition to the writ petition be filed within
2 weeks after vacation.
2 weeks after vacation, full stop. Affidavit in reply thereto, comma, if any,
2
comma,
weeks thereafter.
be filed within 2 weeks thereafter. List this matter for hearing in the combined monthly list of February 2026, full stop. The subsisting interim order, which is to continue till the end of December 2025, shall stand extended till the end of February 2026.
I'm grateful.
My lord, item number 11, I appear on behalf of the petitioner, my lord. My lord, this is an assigned matter. Upon mentioning the matter has been upgraded, my lord. It is a suit for declaration that miscase number 59 of 2007 obtained in the preemption suit is obtained by fraud, suppression of material fact, suit for partition of plaintiff 6/7 share and consequential relief, my lord. My lord, what has happened? This suit in the
What do you
state suit.
want?
My lord, in the state suit, I have filed an application under Order 39, Rule 1 and 2. My lord, kindly on sees the order dated 12th December 2024. On that date, my lord, the hearing of the injunction application was fixed. My lord, from that date, the defendant showing one ground or the other, trying to halt the proceedings, my lord. Few of the defendants, in spite of receiving the summon, did not appear, chose not to appear. Thereafter, they are filing vacating application, my lord. Day by day, my lord, they are coming after
When
one.
was your injunction application filed?
My lord, filed with the plaintiff, my lord, in the year 2022. My lord, thereafter, what has happened?
Very well, I heard you.
My lord, kindly fixes any certain time limit, my lord.
Uh,
My lord, next date is on 10th February 2025.
The petitioner has
26.
approached this court seeking expeditious disposal of an application for injunction filed by the petitioner under Order 39, Rules 1 and 2, before the learned civil judge within bracket senior division, comma, first court at Baripur, comma, district South 24 Parganas, in title suit number 455 of 2022, full stop, paragraph. In view of the nature of the order proposed to be passed, comma, there appears to be no requirement for service of prior notice upon the opposite parties, full stop. However, comma, the petitioner shall be obliged to serve a copy of the application as well as this order upon the opposite parties within a week from date, full stop, paragraph. it appears that although the petitioner had filed the application for injunction along with the plaint as far back as on
2022, my lord.
as far back as in the year 2022, the same is yet to be disposed of, full stop. The learned court below, no, learned trial court, i.e. Trial court, court below legal, learned trial court, i.e. the learned civil judge within bracket senior division within bracket first first court at Baripur is requested to dispose of the petitioner's application for injunction along with any other application. There is an application.
No other applications pending, my
for
lord.
vacation of
My lord, vacating, they are one after another, they are filing vacating application, that is being allowed, my lord, but no other application.
application has been allowed. So your injunction application is
No, not vacating. Vacating order application regarding ex parte hearing against the few of the defendant, since they chose not to appear.
application for along with the category application for injunction filed by the petitioner in the said title suit number 455 of 2022 as expeditiously as possible, preferably within a period of 2 months from the date of communication of this order, without granting any unnecessary adjournment to either of the parties. Full stop.
I'm deeply obliged.
With the aforesaid observations, CO 3560 of 2025 stands disposed of. Full stop. The petitioner shall serve a copy of this application along with a copy of this order upon the opposite parties within a week from date.
Well, or there can be direction to serve upon the copy of this application upon the learned advocate appearing before the trial court.
Opposite parties along with the learned advocates appearing both, appearing for the opposite parties in the trial court.
Deeply.
Against the adjudication order, petitioner filed the appeal petition along with the condemnation petition and the show cause notice served by the appellate authority, and petitioner appeared before the appellate authority. And page 41, the appellate authority mentioned the appellate authority satisfied that the medical from the medical documents of the petitioner, it is observed that the proprietor has some problem in the eyes and were under the treatment of AK Bishas since 14/11/2023 and last visited on 26/12/2023. He's also visited Shorav Das on 10/7/2024 and 18/11/2024 for the treatment of some back pain. But they are not on the basis of the 107(4), the petitioner reject the appeal petition only on the limitation point. The delay on of the 144 days delay.
Yes, Mr. Sanel. Illness ground of somebody.
Medical ground, because your lordship goes to the
Individual.
previous paragraph, page number 41, previous paragraph. It is observed that the order of the proper officer dated 12th April 2024 uploaded in common portal in 12th April 2024. Hence, it was established that the appellant, it was available to the appellant on 12th April 2000. As the order of section 73 has been available in common portal, hence service of the order is done so and so. Again, GST system. So they have been served, your lordship. After
Yes,
that,
they could not file because of their illness.
But your lordship, if your lordship, I'm not objecting to that. But your lordship, there are other people. There are other people and to take care of the accounts also.
No, he's an individual.
He's an individual. Your lordship.
Proprietor. Individual.
Right.
Where is your delay condonation application?
My lord's page, just my lord. Page 29 and 30, and 31 to 39 is medical documents.
लिखे नहीं this writ petition questions an order dated February 28, 2025 passed by the appellate authority under section 107 of the WBGST Act, 2017 stroke CGST Act, 2017, whereby the petitioner's appeal against an order dated April 12, 2024, passed under section 73 of the said Act of 2017 was dismissed on the ground of delay. Full stop. Learned advocate appearing for the petitioner invites the attention of this court to the application for condonation of delay filed before the appellate authority within brackets page 29, annex page 29 to 30 of the writ petition, as also to the medical documents annexed in support of the said application at pages 31
31 to 39.
36 of the writ petition, bracket closed, and submits that the petitioner could not prefer appeal before the appellate authority within the statutory period of limitation owing to the petitioner's ill health. Full stop. It is noticed from the order impugned that the appellate authority has not disbelieved the petitioner's case of illness However, the appellate authority has rejected the petitioner's appeal on the ground that during the period of the petitioner's illness, the petitioner's firm, 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 within bracket, proprietorship, bracket closed, continued with its business, full stop, paragraph. It is observed that the petitioner is an individual and is an individual businessman, full stop. The delay occasioned by the petitioner is not so big, and the reason not so big, and the reasons cited by the petitioner have not been disbelieved by the appellate authority. In such view of the matter, it cannot be said that the petitioner was grossly negligent in pursuing his cause, full stop, if the delay occasioned by the petitioner in preferring the appeal has been so occasioned, is attributable, so occasion is attributable to the petitioner's illness, the same ought to have been condoned, full stop. In such view of the matter, the delay occasioned by the petitioner in preferring appeal before the appellate authority is condoned, and the And what are these cans for? The can be disposed of. One is for interim order. Mr.
Two cans have been filed. One was for the implement of the officer who had issued the recovery notice, and second is for the
So
challenging
that can be disposed of.
No, the second can is for the challenging the recovery notice
which has been
in
issued in
respect of
pursuant to the
the,
order.
in respect of the order in original.
Very well. Then let it be. Once the writ goes.
Yes, my lord, sir, everything.
Yes.
And I am for the petition. In this matter, my lord, I am challenging the order of cancellation of registration.
Lordship, I'm for this respondent number 5 in this matter.
Respondent number 5.
4, Lordship. Union of
Who is the
India,
effective respondent?
Respondent
3.
1 and 2.
1 and 2 you are not appearing.
No, Lordship. I'm for this Union of India.
Who is appearing for 1 and 2?
We have served the petition.
But somebody should appear. CGST. Mr. Bhonjo, Mr. Bhattacharya, Mr. Banerjee.
In fact, my lord, I just my senior told me that the matter is
I also inquired with Mr. Bhonjo.
I'm making it not to take instructions. Come back tomorrow. So short matter, cancellation, revocation.
Well,
Just
keep it
make
on Monday.
लिखे देने order लिखे ना. You take this order and go. That nobody is appearing. None appears for the respondents. Full stop.
Item number 15, my lord. This is tax period, initial tax period 17-18, my lord. And here, my lord, I am challenging the appellate order.
Instruction.
Delay in appeal. And my lord, also challenging the adjudication of Sokornaji because
That you cannot, if you have preferred appeal,
Yes,
delay
yes,
is the only thing which
yes,
you can don't
yes.
challenge everything now.
Yes, yes,
Limitation on the
How
ground
many
of
days delay?
75 days delay, my lord, after 3 + 1 month, my lord. And reasons stated, my lord, para 10 of the writ petition, my lord. Kindly have a look, my lord.
No, not of the writ petition. Before the appellate authority, what was your reason?
Yes, my reply at, my lord, page 69, my lord,
70.
against the show cause notice, my lord.
69.
69. And coincidentally, my lord, reply at para 10, my lord. 69 to, my lord, 74. And, my lord, briefly written in para 10, my lord, of the writ petition. Kindly have a look, my lord.
Hundred and 6 days.
75 days, my lord. After 3 + 1 month. And, my lord, this is unintentional. Their delay, my lord, may be condoned. Delay may be condoned, my lord. Unintentional delay considering this
One
fact.
thing from the appellate authority's order, there are certain observations which I would like to place here before
Yes.
your lordship. I'm not thinking not to object, but It's on the face of it, page 77.
Page 77.
Paragraph 9, if your lordship is on reads paragraph 9, petitioner prayed for condonation of delay and stated a reason for such delay in the annexure due to miscommunication by the previous consultant. Petitioner also submitted separate prayer and stated that with due respect, our firm, I was partner of our firm, would like to withdraw our attention that I could not submit in time due to previous consultant failed to inform the hearing notice, show cause notice along with assessment order and demand order in DRC 07 a period. It is also stated this is there. And now in paragraph 11, upon perusal of the records regarding adjudication proceedings and order arising out of which
Yes,
against
Mr. Rai, he's right.
it was sent to an advocate. So these are observations are being.
Yes.
You pay
but-
cost.
my lord,
Pay
very little.
costs, no.
My lord, this advocate, my lord, suffering, my lord, cancer, my lord, that some treatment going on.
But that is not the ground.
Yes, yes, and that
Then-
is the
then-
some cost, my lord. Some.
Yes.
Kindly consider the
Of course.
cost. Otherwise, my lord, my case, my
That I understand. Don't go on
no
merits.
tax in favor. Yes, I
cannot
understand.
go on merits now.
yes, yes, I understand.
Yes. This writ petition. Yesterday's matter.
This matter, my lord.
Not affidavit of sir.
Sometime, my lord, request to the respondent council so that we can benefit it. Bar can be benefit.
not calling from me.
My lord, affidavit.
Affidavit of service filed to be kept within.
I'm grateful.
We'll
do that.
that subsequent matters will be.
We are for this, we are for 16.
My lord, today three matters. First is, this petition is against the central tax. And another two matters against the state tax authorities. The issue involved. So we are proceeding on, main is the state central tax first writ petition. My submission, 13008.
We have checked up all the matters, the petitions.
Yes, my lord.
Issues
My
are
lord,
same.
it appears, my lord, I must, my lord, candid to your lord, my lord, it appears that seeks to be maybe a bar here. But even then, my lord, we are asking, my lord, if your lordship direct the department to check it up and submit a report to your lordship, my lord, that will be better, because as we have seen from the pre-sequence notice, my lord, nothing has been turned up by the any of the party or the, also we, my lord, sent the notice to the GST authority, they also didn't say anything. That's why order has been passed. And my lord, fact remains 8, my lord, fake suppliers. From them they get all these things, my lord. That is an
Mr. Das,
admitted,
I'm asking them to file a report.
my lord.
Should I proceed? I have prepared a small list of bits as your lordship.
Once the report comes, we'll have a view over of the entire matter, because piecemeal hearing, then they will take time to take instructions, come back again. The report will solve the problem.
Only small indulgence I'm asking. In the meantime, the state proceedings should be, the central proceedings, stay should be granted. Only otherwise they will start initiate the recovery process.
Well,
Please,
after
should not.
consented, I am,
Should not.
should not, my lord. That is, I know.
Huh?
I leave it to your lordship, my lord, I leave it to your.
No. How long I will wait? I am ready to argue this. Their report is not
Very well.
coming. Therefore, kindly short term, next date I have.
This writ petition has been filed.
In continuation of the proper so and so, this is show cause, Lordship. In continuation of the so and so, the
5169 annexure P6. This is an order.
page 55.
Page 60. 55. We have got it.
Page 55. Page 50, P3, annexure P3.
P3 is an order.
P5. Page 55.
P5.
Yes, that is the,
February 2020.
yes.
24th February 2020.
And that is it is starting on page 60 is the main text of the show cause.
Main text is at page 58.
58 states and 60.
Page number
Page 6. 24 দিয়ে দিও।
কপিটা নিয়ে দশটার কপিটা নিয়ে বের করে দিন আমি এটা দিয়ে দেবো
Lordship, this is the একটু দিয়ে দিন দর্শককে।
সবথেকে ভালো হতো দশটার কপিটা বের করে দেন
Pagination and
start ballot the copy kindly choose ballot
page 60. 5169.
Yes, and where is the show cause notice in this case?
This is a list here, page 60. That is the text of the show cause notice. I am reading in a continuation the
Show cause
probe.
notice in this case, in the present case, 1008.
This is state.
1008.
And yes, 157 of the central read. Volume 2.
1307, volume 2. 52 minute question.
না লিস্ট ওই জায়গাটা দেখিয়ে দে ওই জায়গাটা দেখিয়ে দে নাহলে হবে না হ্যাঁ পেজ 164
Page 164.
164
Yes.
in overlapping in view of the above so and so it is evident that so and so have availed and utilized inadmissible input tax credit so and so it is of invoices issued by the non-existent and egg farms, namely centralized merchandise. And this list I have in my statement, I have mentioned all this. What a statement I have given earlier.
The same
Lordship.
suppliers.
Yes, same supplier. List কোথায় গেল? List of
some of them are same the ID that appears
No, exactly. I'm full responsibility. I'm submitting. 100% same. 100%. Lordship, kindly look at this statement. 100% same. It is same amount also. Except one. Except one.
I'm a
eight entities are
তা ওনাকে ফেরত দিয়ে দিতে হবে। আমাদের পিটিশনটা ফেরত দিতে হবে। as regards টা করবেন লিখে দিন ওই সেমনি WPA such and such shall appear one after the other after the যেরকম as regards চালিয়ে দেন।
My lord, may I be permitted to make
প্লিজ ওয়েট, এইটা রেখে দিন তো, ওই 13008 না কি ছিল ফাইল, তার ভেতরে রেখে ইয়েস
May I be permitted to mention one thing, my lord? My lord, it's a matter of PP Act, Public Welfare Commission. I kindly think this matter for hearing.
for hearing means I couldn't understand, it's not in the list.
I don't know. It's not
To
in
give
the-
it, why don't you mention? So it did not appear. Have passed an order now.
Item number 13, your lordship, I fixed it on 13 January. Can it be fixed on 21st January?
On that day you come and pray, I'll make it. Order has been passed now.
My lord, the petitioner filed the appeal petition along with the coordination of delay petition. The petitioner advocate represents the case on the against the show cause with filed a reply along with the documents and relevant case relied upon. And the petitioner received the appeal rejection order which mentioned that the reply page 48 to 72 and first appeal rejection order page 73 to page 76. On the last paragraph, page 76.
How many days delay?
240.
240.
My lord.
Yes, Mr. Chakravarti.
It seems the advocate had expired. P3 is the
Yes.
picture. The what should I?
Page 60.
I'll leave it to Lodge. Lodge will be taking motions matter tomorrow. No tax tomorrow because my lord has a different.
Yes, if that
I'll be requesting if man can take the motions matter if possible time slot tomorrow, day after tomorrow. Because last week,
no motion.
No, obviously motions should be there, but 24th, I don't think second. That's why I was requesting if my lord, I think everyone would agree if some motions matter, tax matter, time slot, it can be taken up Thursday and Friday. If subject to my lord's convenience, I should not be said.
Because unauthorized documents that
Yes, I
they are
understand
not
that.
touched.
I
If
know that.
Friday, Thursday,
If
if I don't take, then they will
my
go for a toss for the
after
entire week.
vacation, my lord can do one thing subject to my lord, a condonation of delay matters. Within 100 days, I think if my lord says we will communicate whatever, my lord can come up and we can dispose of at least 100 to 200 matters can be disposed of.
Yes, that can be done.
My lord,
Ask
cancellation,
also.
non-filing of returns. For these two categories, we can demarcate with the help of my learned friends from this side. We can demarcate and
that will be better because then in that case we will be having separate heads.
Yep.
Whatever heads are there, we'll take those heads and those matters which are contested, then time will not be consumed.
That's
because
what
we also consume a little bit of time.
Yes, ma'am.
Dictating order, correction, this, that.
And whoever agrees for a 10% and thereafter that category, at least 500 matters will be disposed of on this. 500, minimum 500 matters.
Because there are a lot of matters which consume time also.
Yes, Manoj. There are interesting points, Manoj, that refund matter of 2 years, a very interesting issue, Manoj, that requires some attention because there are divergent views. That requires.
Annexure P3, which page?
Page page 60. Page 60. 60.
60.
ও না না আরেকটা আছে না ওটা অ্যানেক্সারের সাথে সরি
60 is something one.
no 32
He was the advocate. Thank you.
This writ petition takes exception Yes, yes, please do that so that if you circulate that and if you give a list, then here we can arrange days.
Yes.
After reopening, we can be more organized.
Yes, Manoj, that's what, Manoj, we
Because this 1 month has been haywire and haphazard, because I also have not been sitting regularly singly, sometimes division, sometimes
Yes, ma'am.
singly, sometimes
can- that matter is still continuing.
many
transfer-
matters are there.
No, transfer matter, NCLT is still continuing.
So there are broken benches and all. So maybe we'll be more organized after we reopen.
All the delay matter are within 100 days. All the delay matter.
All the delay matters will.
May I please, Your Lordship? Lordship, I appear.
Dead SSC.
Yes, Lordship, dead SSC. Lordship remembers, dead SSC. I am challenging the 147. Lordship, only two things. After the 148 was issued, although I never had a copy of the 148, for different years also they were issued. We had informed the judicial assessing officer. Lordship kindly takes up page 20.
Page 20.
20, my lords. Lordship kindly marks the date on 30th of March 2024. It was recorded. Lordship just kindly also takes note of the last paragraph in the letter saying the assessment proceeding has also been dropped for 2 different years based on the same aspect that the person had died in the year 2018. Thereafter, Lordship, 21, an order sheet was handed over to us where such death was recorded. Lordship, what I find from the 147 order is that point of time the system was not the faceless. The 147 order, Lordship, if just kindly takes up for once, page 22 it starts, page 23. Page 23, the paragraph, the first paragraph, Lordship, the fourth last line. Subsequently, the case has been transferred to the faceless unit on 26 June 2024. What? Page 23, my lord.
Yes.
The first paragraph, the fourth last line. Subsequently, the case has been transferred to the faceless assessment unit on 26 June 2024.
Yes.
What I'm inferring, my lord, subject to consideration is, Lordship, that maybe at the time of the change from the faceless, this order which was passed by the JAO recording my death has not been notified, and on basis of that, a 147 order has been passed. Lordship, Lordship's aware of the law, I am carrying judgments, but this is against a dead person. I was just praying that this can be set aside. Then they can take that step, that's fine.
Now, it is very easy to say, under the assessment order has been passed against the dead person. Now, Your Lordship kindly also looked into the notice dated 30th March 2024. But the page 20, my lord, he has already been replaced, my lord, before Your Lordship. But the bona fide HSB, my lord, he has to say that not only the notified the death of the assessee, the legal representative also said these are the legal representative. Because it is the issue of now the addition has been made up to 69 crores and demand up to 47 crores and odd. Now it is also responsibility of the legal representative that see the assessee died, these are the legal representative. Because 159 of the Act specifically says, the Act specifically says about the responsibility of the legal heir. The who hold the properties, some portion he has to responsible for that portion. Now the assessee could not be go free.
No.
Now in this court, Your Lordship already decided in my matter, Kripa Shankar Mawar. Same proposition Your Lordship had decided.
Achha.
In that case, the assessee, after 148 notice, legal representative of the assessee replied in Kripa Shankar Mawar says that assessee died. In the present case, from the assessment order, it appears that several notices has been given to the assessee. When the assessment proceedings were in the 148 stage,
till that the representative of the assessee did not inform, because the assessee died 2018. Information given on 38th March 2024. Before that, when the 148 proceeding has been initiated, the assessee representative of the assessee did not take any step. But what a prudent legal representative can do, that he, after 148 notice, he can file the return on the basis of representative assessee category. Return 140, after 148 notice, return has already filed. But in saying that the assessee died, all responsibility goes, everything goes, that cannot be. My responsible submission before a lordship, the reference, because it is true. Before passing the assessment order, the notification was there that the assessee died. But before at the 148 stage, the assessee could have replied and filed the return on the representative category. But it is not only fault of the only part of the department. It is also my responsible submission is the lacuna on the part of the representative or the assessee also.
But Mr. Bhattacharya, page 21. When the department has come to know about it, department also.
I understand. I am saying
page 21.
Yes,
document.
Page 20. I'm not.
If he has died on such and such, furnish this certificate along.
Yes,
with
it is only recorded on 38th March 2024.
Yes.
The
order comes much later. In the
yes,
meantime,
I am
would have
yes,
corrected it.
correct. I am not on that. I am whatever I am submitting, at the time of 148 stage. That information is not there before the judicial assessing officer, because it was submitted on 30th March 2024. The 148 proceedings has been initiated in the year of 2023. 148 notice issued in the year of 2023. Assessee did not reply. The prudent legal representative can do, he has filed the return on the basis of representative category. I am also not on that. Because the only
now, so this cannot stand.
This cannot stand, but my responsible submission, in respect of the Kripa Shankar Mawad, your lordship already held that, however, in paragraph number 9 and 10, the legal representative should say this is the legal representative, and the proceeding can be done against the legal representative in accordance with law.
Yes, that is
only two things, my lord. Just because my lord senior friend has pointed it out, lordship kindly takes up page 23 once. That is a part of the page 23, part of the 147 order. Lordship, there's the details of opportunities given. Lordship has seen that thing. Page number 1, Lordship 148, and the response is return not filed. The response which I've showed to my lords in page 20A1 that I have already informed, that has not been recorded. Hence, I pointed out that maybe because of the transfer from the junior assessing officer to the faceless, this issue has stepped. I am not alleging.
I am not saying that.
He says that this is not enough. Once you say that he has died,
yes,
you should also.
Lordship, just kindly that's why while I was pointing out that letter, the last paragraph I have pointed out, I beseech my lord to take note, is that it has been for other respective years also the similar stand was taken. And they have also acted upon it. That is my letter. That's there in the last paragraph.
That is so. If the assessing officer, in respect of the RR assessment, he has dropped, that is wrong.
But lordship, that
has to be taken by the legal representative.
I understand.
Not that the assessment order will not go.
And I'm not saying that the assessee office is going to go scot-free. Lordship, they have 10 years. They have their opportunity, man. They have the opportunity. So I'm not, it's not like there's going to be a loss of the exchequer, man. Otherwise, as an officer of the court, I should point this out. They have the right, man.
RAY হবে। Thank you.
My lord, this is that matter, my lord, where, yes. And
Mr. Chakraborty.
my lord, before your lordship, may I add make two more submissions, my lord? Before, yes. My lord, one thing, my lord, it was my submissions that the documents which I had given and the evidence considered. Now my submission is that the respondent number one who passed the order also relied upon materials from that on and did not apply her own mind on borrowed satisfaction. That is, she referred to certain, my lord, letters made by the CGST authorities without herself examining the same. Now, my lord, if I'll show your lordship, my lord, if your lordship comes, my lord, I will not refer to the SCN, I'll refer to the order because in the order, the SCN has been copied, my lord, the show cause notice. My lord, may kindly come to page no, that is the show cause notice. That is the order page. My lord, the order. My lord, I'm coming to it. My lord.
Page 318 is the order.
My lord, 318. My lord, I'm just reading it out to what she has said, my lord. My lord, the facts of the case is that as per the GST database records, my lord, this was in the show cause notice also. This is copied from there. The RTP so-and-so having GST number such and such has availed ineligible ITC from cancelled and non-existent suppliers. So first is they are cancelled and non-existent. Apex Industries 1, it's Kailash Enterprise, such and such, and Konartori, Vinimoy, Exim, etc. Now, my lord, she is dealing with the first case, that is Apex Industries. The RTM such and such has claimed ITC of rupees such and such from Apex Enterprise. Registered taxable person, Apex Enterprise, was engaged in issuing fake GST invoices in fraudulent manners without actual supply or movement of goods. ITC enjoyed by RTP is thus not allowable as the transport and movement of goods is practically impossible from a supplier who does not have any physical existence. Now, my lord, for a business concern having no bona fide existence at his purported principal place of business and who had never conducted any business activities from its purported principal place of business and had obtained registration by means of fraud, willful misstatement, or suppression of facts, and issued invoices or bills without supply of goods to pass ITC is in complete violation of Section 16 of the WBGST Act. So, my lord, this allegation that the supplier never existed, the supplier was fake, and the supplier had issued fake invoices, for which, my lord, she has not given any evidence except, my lord, kindly come to page 320, that is only a document from the central authorities, that is request for cancellation of GSTIN in respect of so and so under section.
But these were supplied to you.
Yes, my lord. All I'm trying to say, this does not establish that the person that is a supplier was fake. All I'm trying to say, my lord, is that she is relying on a document which only says request for cancellation of registration. But where is the allegation in these? What is she relying on, my lord, that this was a fake dealer or a fake taxpayer? He had issued fake invoices. My lord, these are certain serious allegations that need to be established. Now, my lord, and that is that. Now, my lord, if your lordship sees, so far as kindly come to page 330. My lord, now what is the document that is given here, my lord? Request for cancellation in respect of Messrs. Apex Enterprise. And it is said that you cancel his registration. This is to inform you investigation has been made for such and such, West Bengal. No such business activity in the name and style of such and such. And on the backdrop of the above mentioned facts, you are requested to initiate process for cancellation of Apex Industries under section 2019. My lord, section 29(2) does not deal with non-existence, my lord. Section 29, my lord, section 29(2) says if there is a violation, my lord, if they say he is non-existent, then they should initiate proceedings for non-existence.
Which page are you reading? Section 29, which
Two.
page?
My lord, I'm sorry, section 29(2).
No, which page did you read?
3330. My lord, 3330. My lord, kindly see the last paragraph on the
Page?
back, page 330, my lord, the order.
30.
330.
330 is request for cancellation.
Yes, my lord. And the last paragraph, on what ground they are requesting the cancellation. On the backdrop of the above fact, you are therefore requested to initiate process of cancellation of
This
GST.
you are saying it was
My lord,
very well.
29(2). Now, my lord, if your lordship comes to 29(2), my lord, 29(2) does not state that the registration is liable to be cancelled for non-existent. It says, my lord, 29(2), the first part, my lord has the book.
Just a minute, ma'am. Just.
The book is given.
Twenty-nine two.
Two, my lord.
Yes.
My lord, 29(2), my lord has it.
Yes.
Yes, well, it says a registered person, it can be cancelled. A registered person has contravened such provisions of the Act or the rules made there under as may be prescribed. My lord, not mentioned which provision has been violated or which rules have been violated. Then, my lord, B, a person paying tax under section 10 has not furnished the return for a financial year beyond 3 months. My lord, that is also not the case because he has furnished all his returns, which is available from the database. My lord, any registered person other than a person specified in clause B has not furnished returns for such continuous tax period as may be prescribed. That is also not applicable, my lord, because there has been no allegation that this person has not furnished his returns or that he has not paid the tax. My lord, any person who has taken, my lord, D, voluntary registration under subsection 3 of section 25 and has not commenced business within 6 months from the date of registration. My lord, he had commenced his business, he has furnished his returns, and he has also paid tax. Whatever supplies he made, I paid the GST, he has paid the tax. There is no allegation that tax has not been paid by this person. And last is registration has been obtained by means of fraud, willful misstatement, or suppression of tax. My lord, that does not demonstrate that he was not in existence. It means at the time when he obtained the registration, he has made certain fraudulent statements or fraudulent, my lord, has fake documents. But with all that, he could have continued his business. So this is for a different ground. My lord, so all I am trying to submit, my lord, that this does not demonstrate that he has issued fake invoices, he was a fake dealer, nothing like that. Now, my lord, that is the first part. Now, my lord, so far as the second dealer, my lord, he says Kailash Enterprise. Yes. My lord, page 320 again. Page 320, that is the order. During course of, my lord, page 320, claim of ITC from Kailash Enterprise. I'm relying on their documents. During course of action conducted by CGST officers, it was found that Kailash Enterprise holding such and such to be fake and non-existing at their registered place of business. From the field verification report, we got to know that when proper officer went for verification to the declared place of business at such and such, they could not locate any such address. The post office has also mentioned that no such address exists in reality. Extracts of report given below. Now, my lord, in this respect, I must say, this Kailash enterprise, my lord, I came to know only last evening that his registration, I have got, it is a part of the records of the court, my lord, it is of this honorable court. His registration was cancelled on the ground that he has obtained registration by means of false, willful misstatement and suppression of facts. My lord, against this, he had appeared in the High Court and filed a writ application, and I find that I had represented him. My lord, it was not known to my client, my lord. I came to know only when one of my juniors pointed out that, madam, you have appeared in this matter. My lord, since this is a part of the records of the High Court, my lord, I'm placing this for your lordship. It is, this petition was filed. And my lord, that order has been set aside, my lord. That also order I have. My lord, kindly come to page 19 of this writ petition.
Yes.
My lord, it says to it such and such, whereas on the basis of information which has come to my notice, it appears that your registration is liable to be cancelled for the following reason. Section 29(2)(e), registration obtained by means of fraud, willful misstatement, or suppression of facts. My lord, nowhere they said he was non-existent. My lord, my lord, next page 20 is the order of cancellation, my lord, which no reasons. And next page, my lord, against this, the petition, this Kailash Enterprise filed a revocation application. My lord, that revocation application, my lord, was rejected because he did not file a reply. My lord, my lord, against this, my lord, the Kailash Enterprise filed a writ petition, and my lord, my lord. My lord, this honorable High Court, my lord, had set aside that cancellation of registration with a direction.
So what has happened to this?
My lord, thereafter I do not know, but it was set aside on the ground, and it was also stated that they would furnish to me the document. They would not see to furnish to Kailash Enterprise the documents. That order of registration was cancelled, and the portal will be open for him to file all his returns. So, all my lord, my submission is this, that the respondent number 1, the proper officer, did not apply her mind at all. And this, my lord, she is issuing it in 25, and all this has happened in 24. He did not make any inquiry, but she only did it on the basis of borrowed satisfaction without any application of mine. My lord, my second submission would be, my lord, and I must be frank in this, my lord, I did not, this submission which I'm making, it was not taken at the time of reply to the show cause notice, nor have I taken it in my pleadings here. But still, it is a legal question, my lord. I am submitting, my lord, that there is a circular by the central government, of which your lordship is well aware, my lord, your lordship knows better than this. It says that in circular, my lord, this is, where is my circular? My lord, that in all, my lord, in this circular, it says, my lord, kindly come to paragraph 2 of the circular. My lord, this is the sentence. My lord, the board, in exercise of powers under section 151A of the Customs Act 1962, direct that no such authorization, summon, arrest memo, inspection notices, and letters issued in the course of an inquiry shall be issued by any officer other than the board. No, issued by any officer under the board to a taxpayer or any other person on or after 8th day of November 2019 without a computer generated document identification number being duly quoted prominently in the body of such communication. my lord, next is to obtain from the online portal. Now, my lord, 3 makes the exception, and my lord, 4. The board also directs that any specified communication which does not bear the electronically generated DIN and is not covered by the exceptions mentioned in para 3 above shall be treated as invalid and shall be deemed to have never been issued. So, my lord, all these correspondences, if your lordship sees, they do not have, these are by the central agencies on which the respondent number 1, who is a state agency, is relying upon. So my humble submission is that since they do not contain the DIN, my lord, it will be deemed as if invalid and they have never been issued and it cannot be received in evidence. That is my humble submission. Now, my lord, the
Which is
question,
not containing the order.
my lord,
The order is not containing DIN. This is not.
no, the documents on which he is relying on. He is relying on, my lord, kindly see. No, neither the field visit report nor the documents. My lord, kindly see page 330. It is issued in 21/7/2023 by the central authority. No DIN. My lord, kindly see the field visit report also contains no DIN. 329. ওর অর্ডারটা এটা যদি ডিলে যেতেন So, my lord, on this aspect, my lord, I did not take it in the show cause notice nor in the pleading. But, my lord, I am covered by Supreme Court judgment that the question of law can be urged at any point. If your lordship wants, my lord, I have a soft copy. I'll give it to the court officer.
No, that you have given the judgment.
My lord, there's another judgment that, my lord, that if it is not taken in the grounds, still it can be urged.
Yes, yes, that is there. If you want, you can give the judgment. not-
But, my lord, only thing I have a soft copy. I'll give it to the court officers, my lord.
But one beam.
After this is or now? One point come back after this is one point.
Yes, ma'am.
But the beam issue is one that already decided. 2 states have only adopted it. For GST, there was a recommendation by the state. It's the judgment of
It's unless it's not yet
No,
adopted.
but not very similar. My lord, I'm thinking it is central.
This has already been considered. This notification is, I'll give a hard copy the next second.
Gujarat, I have read.
Well, Kerala and 2 states have done it. So, last, this marks one of the last 2 paragraphs. So, it was state that
all should do.
Yes, all should do, but
State has not yet done. So DIN is out. Give me the judgment. For correction, এটা কালকে দিয়ে
Item 15 or the cost time. During that there is holiday manner can be manner 4 weeks. Item 15.
15 কি আমি I don't know if I forget at the time of signing, but then it's one. I will remain 3 weeks. You be prepared for 3 weeks. If you have a bad luck, I will come 4 weeks. Let us pray. Thank you.
borrow satisfaction, documents could have been taken in a different perspective, was not taken in a perspective, and these are all plausible cases. When if my lord says my case, whatever the finding, no right person could have concluded such findings, then only a writ petition is granted. I'll go to that extent. But that is the law, subject to correction. But if it is a plausible case,
because in a writ proceeding, when an order is challenged, I will not test it in the same manner as an appellate authority would have done. I would not test the decision, but the decision-making process. I will not see whether the decision is sound. I will only see whether the decision could have been taken by any person of reasonable and normal prudence. That is the law.
but I could not have put it in a better manner. I'm grateful, man. That is the test, man. Whether I succeed in that test. Kindly see my show.
The decision may not be correct.
Yes, absolutely. Man. That is the test. Jurisdictional error.
Certiorari jurisdiction, the test is I can only destroy
Yes, ma'am.
when certain things are there,
Yes.
when weaknesses are pointed out. I cannot construct. It's a destructive jurisdiction. I can destroy. Appellate authority can construct. They can pass positive orders. I cannot. I will, if I have to exercise jurisdiction in the affirmative, I'll destroy whatever is there. If I can't, I'll have to keep quiet.
Ma'am.
My lord, would kindly come to page 86. This is the show cause matter.
Page 86.
This is the show cause. My lord, because one of the allegations in the reply was that my allegation is this. This was one of the reasons, and that's why I'm showing. My lord, I don't want to page 86. Fact of the case. I'm not placing that. Second, claim of ITC, so and so and so. Second, second part, for a business concern, having no bona fide existence at his purported principal place of business, and who had never conducted any business activity from his purported principal place of business, and had obtained registration by means of fraud, so and so, without supply of goods to pass ITC's complete violation of section 60. But these were the invoice given. Next one. Extract of the report given below thereafter. Next.
When was the order passed, adjudication order?
Madam.
That is
Yes, madam.
4th August 2025.
No, 22.
Yes.
25.
4th August 25.
Yes.
The next is 88. Koilashnath Enterprise.
Which page you are placing, Mr.
First, I place 86. Because
Just-
it is
just
in
a minute.
respect of 3 suppliers.
Just page 86.
Yes.
Yes.
Kunta. Yeah, cancel.
Now, 88. This is in respect of the second
No.
supplier, Koilash Enterprise.
Yes.
Apex na Koilash.
During the course of action conducted by CGST officer, it is found that Koilash Enterprise Holding, principal so and so, was found to be fake and non-existent at the registered principal place of business. When next 90. It was found that Sonatori Vinima so and so was found to be fake and non-existent at the registered. But these were the specific allegations. Well, I don't think there was any vagueness as regard to the allegations that if these persons were non-existent, how could you do any business with him?
But Ms. Mukherjee's principal contention is that you have not considered the documents that have been supplied to the have been furnished before the adjudicating authority. The adjudicating authority has not considered those documents, not properly appreciated them.
Appreciated and not satisfied. I have said in my capacity in adjudication that I was not satisfied with the outcome. With those invoices, according to me, those documents cannot be considered. It was my finding. A little bit of discretion has to be there, my lord. Today, my lord, a discretion has to be, and my lord, whether it is an absolutely, my lord, if it is found by a authority prescribed under law to cancel a registration, who is prescribed under the law to find the.
That was in fact the main basis of Ms. Mukherjee's challenge. Non-consideration of documents gives rise to substantial to a question of law, and that leads to perversity. Therefore, High Court should intervene. That was the
Yes,
and two new grounds have been added today. One is borrowed satisfaction, and the other is non-application of mine.
Yes, madam.
Because of borrowed satisfaction, the adjudicating authority has only acted as a satellite. It is not shining in its own light.
318, madam, kindly. Well, what is constitutes as a non-application of mine or an application of mine to the not to the satisfaction of the people? These two things are different. Well, kindly 318 is my adjudication order. It starts.
Yes.
Well, 324 onwards is the case that is made out by the petitioner hearing. Thereafter, one by one. Well, last paragraph. In the present case, the department has conducted an inquiry into the supplier.
Yes, I have read that. You placed it last time.
Yes. A similar case, that also I have faced, but it is not possible. Possibly next page, 325, I have also. But in this particular case, the supplier never conducted any business. And they use forged documents to get registered under the CGST. 325, the first, second paragraph. But later on, physically, it was found that no business activity was ever conducted from the principal place of business. It was then the suppliers were retrospectively cancelled ab initio. Non-existent entity means no stock. No stock means no delivery of goods. No delivery means non-receipts of goods. Bank payments should also align with other statutory requisites of IPC claim. Now, next paragraph, the last 4 lines. The last 4 lines,
it should be possible that Ms. Mukherjee's submission on this was that this is a conjectural conclusion.
But this is when there is a non-existence accepted. It is a case of collusion, my lord. It's a case of collusion. It is not a case where the selling dealer is existent or the selling dealer was doing business. It is a case selling dealer was never doing any business. But the other way around, the purchase. But the last 4 lines, can you see? 325, the paragraph start with noticing.
Yes, I've seen that.
While
it could be possible that the vehicle was unloaded during movement of goods or goods were delivered at some other places.
But the last line is very important. Therefore, there is definitely collusion between the suppliers. Well, this cannot be said there is a case of non-application of mines. But I have, in my own way, an officer has considered the judgments, have tried to distinguish those judgments, and have come to a finding that there is a collusion. Now, just on the other day, in the Jyotitar matter, my learned friend, Mr. Ankit Kanadi, had relied upon certain judgments. But I'm handing over. One of the, I had said that I will try to distinguish those judgments.
Yes.
He has given in the notes. This 97, it had another copy. 97, 11 SCC, 378. Supreme Court says, the Supreme Court.
Jyotitar was supposed to appear today only. No?
He is appearing, the below. I would request, if can be taken up before the.
Yes, because I also wanted to filter. Jyotitar to niche chale gelo sir. To urgent appear korichi. ওটা কন্টিনিউইং ম্যাটার হিসেবে একবার উপরে কারণ শুনে নিতে হবে, হাত শোনা আবার ভুলে যাবো।
ভুলে গেলে আপনি শুনুন।
সোমবার দিয়ে দিন।
Well, Monday from Mr. Kanodia is not there, I know that. Just told me. If my lord can Friday, 5 minutes, I'll take 5 minutes. He has relied upon some judgment which in the notes which he had never shown.
From Monday onward, he will not.
No, going for a vacation. Early vacation. If my lord Friday 10 minutes, my lord gives, I'll finish. 5 minutes to the clock. 5 minutes to the clock. But I have exhausted that.
Only one Jyotitar is appearing. There were
No,
two.
yes, two Jyotitar is appearing.
Because I also had a mind of, because those were substantially.
Well, one is 39, another is 46.
Very good. 39, 46 का ऊपर काल के तुले दी। हाँ। देखिए আমি কথা বলি।
Judgment টা দিয়েছো? Oh. 97. Kindly see paragraph 5, which is the proposition of law my learned senior friend is saying. Kindly see paragraph 5. In our view, the High Court was right. A purchasing dealer is entitled by law to rely upon the certificate of registration of the selling dealer and to act upon it. Whatever may be the effect of a retrospective cancellation upon the selling dealer, it can have no effect upon any person who has acted upon the strength of a registration certificate when the registration was current. The argument on behalf of the department, it was the duty of the person dealing with registered dealers to find out whether a state of fact exists and should justify the cancellation of registration must be rejected. To accept it would be nullify the provision of the statute and would entitle persons dealing with registered dealers to act upon the strength of registration certificates. It must also be noted that the learned Advocate General appearing for the department before the Honorable above the High Court stated that the genuineness of the transaction between the registered dealer and the respondent was not in doubt and not disputed. But this is the distinction. But I am basically but this is the principle of law. If it is a case of fraud, it cannot be malicious. This is the judgment. And I had already relied upon 2020 volume 12 SCC 570. Actually, this judgment Mr. Kanodia had shown in his note, it is helping in 9711. That which I showed my lord. That is the distinction Supreme Court is also.
Relied this,
in 9711, he relied upon.
And this you relied?
Yes, I relied upon.
Para?
Para 14, my lord, onwards. Because according to my learned friend also, he has not all the objections. It has also been laid down by this court that the excise law is a complete court in itself, like GST. And it would normally not be appropriate for a writ court to entertain a petition under Article 226 of the Constitution, and that the person concerned must first raise all the objection before the authority who had issued the show cause and redressal in terms of the existing procedure of the law could be taken resort to if an adverse order was passed against such person. For example, to answer the complete court. But that is what I was relying on. There are two layers. There are appellate order, tribunal. Thereafter, again, another knock before the Honorable High Court in the second. So there are different layers to this procedure. And this is not a factual finding. Today, if my lord wants to have to interfere, my lord has to interfere that there was no collusion. Because if my lord wants to set aside, because that is the specific finding. My lord may not be to the satisfaction of my learned friend, but my lord, it is not cannot be said a reasonable person upon considering the documents will not come to that conclusion. It is the test, my lord. I request my lord to adopt that test. And my lord, borrowed satisfaction, our authority who is entitled under law to take step, I have relied upon those documents. At the stage of hearing, he has not rebutted such findings. He has never rebutted such findings. He has never complied with the documents which we wanted at the same time. And the ledger books in that paragraph, all the things are there. But this would be a finding to the fact. My learned friend has basically invited you to go into the facts. It's not a case of jurisdictional error, not a case of natural justice, or not a virus. That is my submission.
My lord, I'm rebutting this. First of all, my lord, it has been stated that this is a finding of fact. I'm only coming to that part of his argument, which is from page 325. He says, where the suppliers had no bona fide existence and had never conducted any business activities from his place of business. Where from she got this, that the persons had never conducted any business activities in that place.
That is from the report.
My report says only cancel the registration.
No.
One report.
No. If you, ma'am, kindly take.
Yes, my lord. My lord, I'm
page
seeing.
330.
My lord, what is the report? It says.
Please take page 330.
330, yes. It says
First paragraph, last
yes.
line.
This is to inform that the
First paragraph, last line.
Yes. And
no such business entity in the name and styled is found that their declared address has mentioned above.
Yes, my lord, when they, on that day when they went, my transaction. So she has come to the conclusion on this, but did not go into the her own inquiry and says that it is only possible from the suppliers to make outward transaction and passing on ITC only by fake invoices. Where is the evidence? Fake invoices have been issued and without any movement of goods, despite my producing the e-way bill, which is a legal document. Therefore, there is a definite collusion between the suppliers and the recipient showing such paper transactions. My lord, there has to be, if an allegation of fraud has to be made, there must be some something, my lord, which is beyond reasonable doubt. Which is beyond reasonable doubt that it is
beyond reasonable doubt is different. That is for criminal.
No, I'm saying, but the fraud has to be. It cannot be. You were saying it is. I have committed fraud, my lord. But then, my lord, my
only preponderance.
What?
Civil cases only
Preponderance. But a fraud is being.
Beyond reasonable doubt to be a case too high.
Yes. But you were alleging fraud, so you have to. They have to establish where is fraud and fake, nothing fake, and why. Everything, my lord. There was no reason then to give me a show cause. You have found those documents, whatever the CTSC or
no, they gave you a show cause for
what? Yes, but if you have come
that yes, they had business or something of
yes.
that kind.
Yeah. And my lord, kindly come from the beginning, which was a part of the show cause, a preset mind that it is forged fake. It is forged and fake. Maybe on that particular day, that person maybe was not. And I will show you from the next petition. It says that the dealer was there 6 months. She had left. The taxpayer was there 6 months left. So it means that are no business. Not only that, my lord. And my document. Why that should not be relied upon. She had never said during the course.
This document has not been relied upon.
My lord, she has never said.
This document of yours.
My lord, now.
Ma'am, the test of
he has never asked for
the test of perversity is not based on non-appreciation of any and every document.
No.
The document, non-appreciation whereof has been alleged, has to be shown to be so germane to the proceedings, has to be shown to be so basic that if that document is not brought within the scope of the decision-making authority, not taken into consideration by the decision-making authority, then in that case the decision would have been just the reverse of what has been.
My lord,
actually has been taken. If that is the case, only in such cases perversity will creep in. Otherwise not. You have to show that the document which has been left out of purview was so important that if it had been taken into consideration, then it would have led to a contrary fate of the list.
My lord.
Is
your
document so
my lord, my only document under the GST Act to show movement of goods, my lord, it says 138 that no movement of goods is permissible unless rule 138. One. 138. My lord, rule 138.
Rule 138.
My lord, the first document. Every registered person who causes movement of goods of consignment exceeding such and such values. Shall, my lord, in relation to a supply for reasons other than supply, due to inward supply, from an unregistered person, shall before commencement of the
So
movement.
therefore, this is a document which you take, which you generate
Yes.
prior to the commencement of.
And I have to carry it. Yes,
because
now my
this
lord.
is real,
My lord, did she say that there is an irregularity in your e-way bill? There are others who say.
Not required to say, ma'am. This
Then,
only
my
says
lord.
that it has been generated prior to the commencement.
No, and I have to carry it
That
along
it has
with the
commenced.
movement of the goods.
That it has commenced and it has actually happened.
Yes.
What will be, how will you show that?
My lord, that it has happened. I am carrying. Now, what is it? Has she said? Then, my lord, yes, there are officers who find that you did not go through this toll tax. You did not go where you went from Jharkhand. You said you were coming.
Why should these documents not be produced then?
My lord, she never asked. She never asked in the course of proceedings.
Not
Call for
required
the
to
records.
ask for every document.
My lord,
But
if I am
the
giving you,
allegation, if the
my lord,
allegation is as grave as
my
the
lord,
one we noticed in the notice to show cause, the authority is not required to tell you if
my lord,
these are the documents.
no, my lord, for movement of goods, my lord, may I humbly submit? For movement of goods, according to me, the legal document that I have to prove is my e-way bill. If the officer is not satisfied that this e-way bill, although I've generated, there has been no movement of goods, there is an irregularity in the movement of goods. There is my owner side is such. It is for him to show or her to show that there has been no movement of goods under this e-way bill. There is no allegation as such. It is possible, she said, for as per section 2, it is possible if there further, when we said if there was no further, there were no goods, how could there be? Further, there is a failure on the part of in compliance of section 16 it could be possible that the vehicle was unloaded during movement or goods were delivered at some other place. It could be possible.
Which you have already said.
And so there has been no finding. And my lord, if it is the other documents which she answered, she could have said, look, I'm not satisfied with your documents. She could have said, look, you have produced, these are the e-ways that produced. I found that these goods did not come from there. She never did that. She had come right from the beginning with a preset mind and an arbitrary mind that because they found that I'm non-existent. Maybe my lord on a particular day I was not non-existent. And that was subsequent to my transactions with them. And I have repeatedly stated in my reply, please give me the details of who made the inquiry. You were giving me a truncated portion. Please cancel his registration. And in one case, my lord, he is relying on somebody having said no, but no signature of the person who has said no, this document, he did not, there is no business activity here. So, and also I've stated, my lord, that in the absence of the, he is relying on certain documents as evidences, which those documents are invalid and are deemed not to have been issued because there is no bill. And my lord, if she had, I'm willing to say, if she says no, she's not satisfied with my documents, let us say, I'm willing to go back. My lord, all I'm saying that let it be remanded to the adjudicating authority. And if these are the documents she wants, we will produce.
I'll consider it.
Yes,
I'm keeping it on one more page. I'll go through these documents. Well, if necessary, I'll reserve judgment then.
My lord, yes.
I will stay under the same heading. Yes, it will come under the same heading.
When we come. Different year, same petitioner, but the suppliers are only two people and the identical, my lord, order. My lord, my lord, order is identical. for this also. That they have never existed.
Where is the order?
Manner, order is yes. Manner at page.
Page 202.
It starts from 202 to 208. And my lord will remember it also because it is identity. Yes. My lord, kindly just see, my lord, the same language. Kindly come to 208. My second paragraph. The noticing has failed to prove the receipt of goods. It could be possible that the vehicle was unloaded during movement of goods were delivered at some other place. And a page 308 times. It's actually a copy of that order. My lord, towards the bottom of second paragraph.
Page 208.
208. 208, my lord.
And there are extracts at page 203, 204.
Yes, madam. And it's a lot very interesting, my lord.
203.
My lord, the my lord, kindly see what they have said. It is that they have never existed and never conducted business. My lord, kindly read from the field verification report, we get to know that when proper officer went for verification at the declared place of business at such and such, they did not find any nameplate or signboard on the or the trade name of the after searching each and every possible corner of the store of the building. The team of officers then met Mr. Niraj Bhuwania, who introduced himself as the proprietor of such and such. He opined that there is no existence of so and so. So and so, I'm the proprietor in this particular premises. As they had left the premises more than 4 months. My lord, does it mean that they have never existed? On the date when they went for inspection, we said 4 months back, the proprietor has left this place of business. So from how it can be gathered?
This has to, I have to also consider. Once Malad take, if Malad find a decision, then Malad, we can come up after vacation on this matter.
Yes, because this will require hearing.
Yes, madam.
Heard, then why do we not take that also after vacation only?
Yes, my lord, all together, both are together.
Hello, 25. Here, my lord, challenging the appellate order, adjudication order, focus notice. Appeal, my lord, rejected on the ground of limitation, and in the 30 days delay, my lord, and
What is the ground?
my lord, para, my lord, बोलो तो हम ऑफिस है para 9 बोलो.
No, para 9.
Oh.
Where is the application for condemnation?
Yes, my lord, page 8P1, my lord.
Show me what you had presented before the appellate authority. Don't show me what you have written in the petition.
Yes, my lord. Sorry, I'm sorry. Condemnation, my lord, page 8P1 and 8P2, my lord. Actually, 28 days. But the adjudication order, my lord, uploaded in the portal only, and my lord, only communicated portal, and also at that time, my lord, the telephone received from the department. Thereafter, my lord, filed the appeal. That is narrated in the para 9 of the petition. Also, some period, my lord, medical also, medical reason also.
Listen.
have Lordship kind leave to file the supplementary affidavit to bring on record.
Where is the document showing that we have paid 10% in terms of 112?
My lord, kindly come at page 129.
129.
Yes. Kindly give me a moment. This is the form 3
Yes.
that kindly come to serial number 4. Section under which
Serial number 4.
4.
Yes, section under which voluntary payment is
The 112. And I have paid that 10% of the disputed. And I have also uploaded the form 3A, my lord, which is at page 133.
So all three total 1, 2, and 3, this 3,000, 1,45,000, 1,45,000, all these three action aggregate will amount to the payment under 112.
Yes, 10% of.
Yes, Mr. Chakravarti. If this has been paid, then in that case, there should be no problem. Full stop. Full stop.
And they have already recovered, in addition to this, 1,50,000, which I have handed over to your lordship, that supplementary affidavit. Kindly come at page 7.
Yes.
The addressing, after the addressing the client, dear Niranjan sir, this is to inform you that your electronic cash ledger
Has been debited for an amount of 1,50,000.
yes, yes. That is in addition to that, and after paying that.
Very. Supplementary affidavit Bad luck. Bad luck. Whenever he is ready, you were not there, but on one fortunate day you were there, then he was not there.
My lord, the point is.
Now time is not there.
My lord, I won't take much of your lordship's time. The point is very short. Show cause has been issued without considering the reply to the pre-show cause submission. So there was an intimation that was given. Reply was supposed to be given within 5 days. Reply was given within 5 days. Show cause was given 2 hours after the reply was submitted, saying that no reply has been submitted. Here's the show cause. Assessee is only saying, assessee is not seeking the quashing of the entire proceedings. Assessee is simply saying, if they wish to issue the show cause, let them issue the show cause, but let them consider the submission.
My lord,
Jyotita.
what happened in this matter? We have issued the pre-show cause consultation note in 19 June 2025. We have given the time to file your reply to the pre-show cause consultation notice.
5 days.
Now 24th June. Now what they've done after office 7:57 after 7 p.m. my lord, they have given it 7:46. They were intimated through email that this is our preliminary reply. Now on the next day at 10:46, my lord, we have issued the show cause notice. We have given them opportunity. Now, if your lordship kindly see the date of the show cause notice is June 2025. Now, when they are coming before your lordship in the month of September 2025, already we have given 30 days time. Do you give a reply? They have not provided the reply.
No, they're challenging the show cause. So how can
Yes,
they participate?
within 30 days we have
No,
not
how
come.
can they participate?
And
Your lordship will-
another thing is that we have given the opportunity of hearing. 3 opportunity of hearing have been given to them.
While the petition is pending, your lordship will kindly see page 58.
Page 58.
Yes, my lord. That is the show cause intimation. Rule GST DRC 1A. So if your lordship sees the date is 19th June 2015. Now, if your lordship comes to 2025, I apologize. 2025. Now, if your lordship comes to page 63.
Yes.
If your lordship comes to page 63.
63.
Yes, my lord. This is the email under cover of which this notice was issued. Your lordship will see from DGGI. This is page 63. There's an email in the middle of the page. Your lordship will see from DGGI KZU. And this is addressed to the company.
Page 62.
63, my lord.
Yes.
Your lordship will see in the middle of the page, there is a forwarded message.
Yes. 19 June.
And your lordship will see the time. They are talking about after office hours. Your lordship will see the time when they issued the DRC money. This is at 8:06 p.m. Now, if your lordship sees the previous page, page 62, they had only given 5 days to respond. Your lordship will kindly peruse the letter.
I told one. I did, Mr. HON'BLE, even according to the timeline, it will be 7:40.
The proceeding, my lord, is the irregular availment of IT. The proceeding
Very
is
well, but you consider this issue of show cause again after.
Yes, my lord. I'm not pressing limitation.
My lord, over here, my lord, time is the great factor. My lord, at his own whims and time, he will approach this honorable court under the equitable jurisdiction. My lord, this cannot be done. My lord, kindly see the date. My lord, the date of the DRC 01 has been issued way back in June, 19 June 2025. On 24 June 2025, he prayed for time. And on the next day, that is on 25 June 2025, the SCN has already been issued. Now, from 25 June 2025 till September, what was it doing? Because it is a time-bound.
That explanation
came later on that.
That explanation I can give, my lord.
The Jyotikar judgment came later on.
And I can also
that becomes the basis of this.
Maybe, my lord, but he has to, if he is agreed with that time limit, that
I'll give my explanation, my lord.
my lord, both cannot go together. My lord, if he had been very much aggrieved that DRC 01 or the pre-consultation, whatever is there, has not been addressed in its proper perspective, then the next day he should have approached this before this honorable court or before any forum. But now at this belated stage, when the show cause has pre-show cause has merged with the show cause notice and opportunity of hearing has been given, and he is not appearing or whatever.
While the petition is pending.
Well, a mere pendency of a writ petition without any interim order, well, that does not inure to the benefit of either
No, my
of the
lord.
parties. Mere pendency, you will have to demonstrate that from.
I cannot come before the writ court and also.
Both cannot argue together.
I will complete my subject.
Well, only my respect short submission will be that from June 2025 to till 23rd September 2025, what was he doing? When he was aware that show cause notice has been issued. Now, whether your lordship will turn back the clock and go to the date as on 19 June 2025, when 19 June has merged with 25 June 2025. These are my subjects.
My lord, there are two aspects. So first and foremost, they are saying that even during the pendency of the writ petition, while the show cause is the subject of challenge, the assessee should participate in the proceedings simultaneously. Now, for one, if the assessee comes to the writ court and says that I am not seeking any alternative relief before any other forum, and parallel to the writ petition participates in the proceedings, he undermines his own case. Second thing is, insofar as the delay is concerned, I wish to bring it on record that I was briefed in this matter much sooner than the petition was filed, and owing to personal reasons, I could not complete the draft and fulfill the obligations of the client. So it is entirely on personal grounds that the writ was filed in September. After the writ was filed, they proceeded with the hearing notice. There were several in December that they gave.
Why not? Because that is the ground validly available to them. That's an important.
My lord, in June.
Because writ remedy is not one of right.
I understand, my lord.
It's not one of right.
And
it's private.
My lord, preliminarily, my submission is, it was towards the end of June that they issued the show cause notice. Writ was filed in September. And the challenge was, the only argument is, they should have considered the submission in the show cause. Yes, ma'am.
That time also it was not filed. That is what they are harping at.
Yes, my lord. Now, that if the show cause is the subject of challenge, if they are seeking legal consultation, if 3 months has lapsed, is whether that is fatal to the assessee's case, that I leave to your lordship's discretion. And I wish to come on record saying that there are personal reasons for which I could not fulfill my obligation. Perhaps that is something that the petitioner has not claimed in his petition, but I can say at least on my end there was some lapse. But even apart from that, preliminarily, I am not saying that let the proceedings be quashed. I am saying let the proceedings progress properly. In the show cause notice, they have actually said assessee has not submitted replies. They are giving 5 days time to reply. Assessee has replied within 5 days. Assessee has given 100 megabytes of evidence, and a show cause is being issued saying, expressly observing, assessee has not submitted evidence. Let there be an answer to that. They cannot capitalize on that.
Why not this? Why this? Suppose he is right, he has come late. But does that deprive him of the opportunity of his reply being considered by you? Well, that because see, you give him 5 days to reply. Within that 5 days, he replies. That is admitted. That is clear from the record. He has not gone beyond the period of 5 days that he himself confined him to. He replies within that 5 days. You don't consider his reply issue.
Yes, my lord. It is, my lord, in normal sense, my lord, we also argue both ways. But over here, when the show cause notice has been issued, my lord, rightly, wrongly,
then there are if there are two contingencies pitted against one another. One is non-consideration of reply, asking him to show cause, he misses the stage. One is he has delayed. Which one should be given preference?
Well, that is why your lordship is there. Well, we cannot, we cannot. Well, that is the reason why.
I shall put this show cause in abeyance. You consider his reply to this show cause. You come to a finding If upon consideration of the so-called, you reach the same conclusion, we will proceed with this.
My lord, I'll make it simpler. I'll make a concession on my end for the interest of both parties. Your lordship will kindly come to page 97. Now, your lordship will see, because 5 days was given, during the pendency of this petition, the assessee kept obtaining and collecting evidence. These are basically transporters' declaration. The case is that there are fake invoices and such and such. So the assessee had to investigate. Now, the assessee found out from the GST portal that some of this, the registration are active. So they supplied that data. Then subsequently, they collected further data, including photographs of transporters who said, yes, we have gone. So the assessee's contention is, let this submission, which they have collected to date, let a direction be given to them to consider it for the purposes of the hearing, and a chance be given for them to make a final submission.
Malad, there is, Malad, over here, Malad,
They should not have an objection to this.
Show cause notice has culminated into a show cause notice.
That is what
Yes,
I was
Malad.
saying. I was saying, he goes a step further. He says you consider this. Allow him to, you want to participate with this?
I will participate. I just want this evidence to be considered.
So this evidence also you consider while, as a part of his reply to the so-called.
Absolutely. I have no.
This evidence which he has given at page 97. Lord, you submit this as a part of his
Annex,
reply to
yes,
the
ma'am.
so-called.
Your lordship, my only prayer is your lordship will kindly consider, record this annexure P5.
Yes, yes, definitely.
Very good.
This you submit again with the reply to this.
Absolutely. Yes, absolutely.
And that will be considered.
Yes, yes, my lord. And a right of hearing be given,
Yes,
because they
yes,
have
yes,
exhausted
I-
their right.
Kita ni lah.
will also take up today or tomorrow anything, because the difficulty is I am an HEZ unit. I am entitled to certain benefits and privileges. While all along there was an issue on the challenge to and which is now matter pending before the Supreme Court. The demands have been come. I am covered by Supreme Court order. But now the state has come up with a scheme, settlement scheme to close it by 31st of December. I have gone and gave a representation. Look, I am an SEZ unit, not exempted from any tax. While they say so, but I have given a representation, and I want a representative to be considered so that I can take an informed decision. It's there. The representation will be considered by Monday. No, my learned friend is there. I have already served. If it is
Who
considered
is
by
appearing for the other side?
state of Western, I think my learned friend, Mr. Honorable, is appearing. But
You are there, Mr. Chokravarti.
The representation by entry tax matters cannot happen in court. They want to get a representation heard. But I can dispose of the reputation
by directing my representation to be heard, and they should decide it by
Very well.
21st.
Today, it may not be possible. We are already almost 3:30. So original side people
I
will
agree.
shout at me. So
Tomorrow after
we'll
that
have it.
fixed matter at 10:30, that's the Reliance we have only there. Great. Item number.
We have made a critical but in the movement appear tomorrow then. Tomorrow after the fixed matter, I think. There is a fixed matter tomorrow.
Great.
Great. Original site. Go on.
One and two. One and two.
What for any reason? You'll also this matter stand ready from this list on my personal grounds. Let this matter be placed before the honorable the activity for appropriate mention.
Second also
But, all of them. All of them which are appearing under to be
My lord, but this is expiring in December. Interim order is expiring.
Yeah, signed immediately. You have still have.
Mr. Bhattacharya is appearing on 1289.
Give the name. 1, 2, 3, 4 same order করে দিন আলাদা আলাদা করে দিন give the name have released same order release এই ফাইলগুলো আজকে ছেড়ে দেবেন assignment করে
In this December, this is expiring.
You are appearing, Mr. Datta. You are
common,
appearing,
but
Mr. Bhattacharya is appearing.
affidavit in opposition.
Not prepared, my lord. Kindly extend the time, my lord.
लिखे नहीं This matter is appearing under the heading extension of interim order upon being mentioned therefore. Full stop. Mr. Bhattacharya, learned advocate appearing for the respondents seeks extension of time to file affidavit in opposition to the petition. One stop. Let affidavit in opposition to the petition be filed within 4 weeks from date. Reply thereto, if any, be filed within 2 weeks thereafter. The interim order, which is subsisting and is to continue till the end of December 20. Pick who is there for the respondent. Pick Tilak Rai.
Was that
So it's there. Not this. Then nobody is there. It goes unrepresented. Please, bottom line the same fact. This matter is appearing under the heading. Therefore, none appears. None appears for the respondent. Full stop. The interim order, which is subsisting and is to continue till the end of December 2025, is extended till the end of February 2026 or until further orders, whichever is earlier. Full stop. List this matter in combined monthly list of January 2026. That's a supplement for Similarly, not. The opposition is ready, but the junior is yet to be up. The order is in a fast number item. Fast officer. Same as well. Opposition 4 weeks, 2 weeks reply, extended till end of February, monthly list of February.
Eight and nine, Mr. Bhattacharya is
Affidavit?
Affidavit is not complete. Finally, extended the time.
Oh, same. Affidavit is time. 5, same as 5. Anti-water is extension of include. 9. Similar. Same. Affidavit in opposition, not 5.
Not 5.
Same thing.
There.
Your Lordship, I appear for the intervener in this application. I'm led by Mr. Deepan Kumar Short. I'm praying for an order today. Please.
Hearing matter is continuing.
In respect of the intervention application, I was asked to make submissions on that. Very short, I will make submissions. this application is being filed by, if you would kindly see the petition itself, the body, that it is a humble petition on behalf of Tea Association of India, a registered trust, to Mr. Such and such secretary. And in the body of this, they say why they want to intervene is that their commercial interest is being affected because of this. First point is this, that it is not even a legal persona. A trust relates to property. Trust relates to not a person. So, my lord, if a trust is to come, trustees have to come forward. It is not the trust. So, this petition is not in the form which can be filed. One. Number two, my lord, is this. But certain things really have come up after this. That why certain things have happened. That certain things which were not at all necessary had been implemented by the from this petition, my lord, I came to know about this, why this matter and this kind of a proceeding about this declaration came. Because they say that because of the competitive exports, their market share in the exports were going down and they were suffering losses. And that is why they did it. So this, in respect of that, my lord, really, if one those cases, they are not a legal persona, but an association can never be an aggrieved person, can never be a party affected. Neither they can file a petition nor they can intervene a petition. My lord, I have one judgment of our High Court in this regard. And my lord, first, if I will be quickly, I will be placing.
Maybe get a copy, my lord.
This is 2009 FCC Calcutta 732. Paragraph 15. The words person aggrieved do not really mean a man who is disappointed of a benefit which he should have received if some other order has been passed. A person aggrieved must be a man who has suffered a legal grievance. A man against whom decision has been pronounced which has wrongly deprived him something or something refused him something or wrongly affecting his title to something. Paragraph 16, reference was also made to the decision of Director General Ordinance, factories, employees, etc. And the Planet Court observed the recognition given an employee association is only a status in its relationship when dealing with the employer. It has nothing to do with the representation of its members in litigation before a court of law. Then, the paragraph 18, that though it were dealing with the service matter here, the last 3 lines after this I read it. In case of Tamil Nadu, Uttar Palli, state of Tamil Nadu, that this is a well settled by series of decisions in Supreme Court that no representative writ can be filed in service matter. Instead, aggrieved individual alone can file the writ. Yes. This is settled. But
is not a person.
Not a person. But
That is only an obligation.
yes, but one thing very interestingly came. The Supreme Court has said that 4 kinds of person intervene in the proceeding. One is the person aggrieved, another is a stranger, and third is a busybody, and fourth is middleman interloper. That is all the 4 terms which this court has used. Only for the purpose of reading that.
We get a copy.
Yes, my lord. This is 1976 1 SCC 611. 1976 1 SCC 671. This is, my lord, 4 judge bench decision, my lord, paragraph 37. So here they are acting as a busybody. And what the court has said, it is something it is delighting. it will be paragraph 37. It will be seen that in context of local standi to apply for writ of certiorari, an applicant may ordinarily fall in any of these categories: person aggrieved, stranger, busybody, or meddlesome interloper. Person in the last category are easily distinguishable from those coming in the first two categories. Such precious interfering in things which do not concern them. But here, no exporter has come. This tea association, somebody who is not at all a legal entity, has filed it through the secretary. If a person is being affected, he can himself become a party to this. And I have become an applicant number 2. So that is what the Supreme Court was saying, my lord. They misquoted as crusader for justice. That is what they do. They pretend to act in the name of pro bono publico, though they have no interest of the public or even their own to protect it. They indulge in pastime meddling of judicial process, etc. Last line, High Court may do well to reject. I'm not 39. Is this? When it was being rejected, paragraph 9 is which says that commercial interest is not a factor, which is what they're espousing. So, at this juncture, so far this application is concerned, I am saying this is not tenable. My lord has asked me this question vis-a-vis that I had stated this, that compliance of this multi-origin in the documentation is in derogation of the provisions of the other substantive acts, which will make my goods liable for confiscation under the Customs Act, under the international law, and so this is in contradiction of the statutory laws governing the export. My lord had said this, that show me those paragraphs where this has been shown, my lord. I had marked those paragraphs, but we can see first paragraph 23 of my petition. None of it is denied in the affidavit in opposition. None of this paragraph which I am pointing out. 23 minutes. I will read it little bit of this. 23. I will read it from the bottom, from the middle of this in the trade notice. In the 1, 2, 3, 4, 5, 6, 7, 8, 9 line. Para 23, page 10. In the trade notice, it was suggested that where imported tea used in captive consumption, finished products need to be addressed and mentioned as multi-origin, which is not a defined term under the Tea Act, and in relation to export, import, mentioning of such term would be in derogation of the applicable law. This derogation of the applicable law is, this fact is not denied anywhere in this affidavit. I have elaborated also how it is derogatory in my other paragraph. If final processing is done in India, it needs to be mentioned Indian origin, and mentioning of multi-origin would be in conflict with the international law relating to documents which needed for international trade, which does not recognize multi-origin in export country of origin. Can kindly see this? This paragraph is not being denied. I can show this from the counters, the affidavit of position they have filed. This is not a fact which has been said. I can show other paragraph and thereafter then we kindly see paragraph 39. Page 16. Petitioner states that the notification dated 22nd December is issued without authority of law, without jurisdiction, and is vague and in derogation of and contrary to substantive laws of the country, and it does not and cannot amend statutory laws. Trade notice is issued against the public policy of India. This paragraph is also not denied. This is not denied. Then we kindly see this, the paragraph 41. The notification dated 22nd December directing the goods to be described in particular manner in derogation of the Customs Act, Foreign Trade Development Regulation Act, TAC would be liable to be quashed, and here is the repetition of it, and it is not done. Then, my lord, page 28 is para 28. Paragraph 28. This fact is also not that petitioners state that the country of origin cannot be termed and mentioned as multi-origin in the declaration and statutory documents to be used in other statutes which control export and import. Foreign countries do have their legislation and do not provide any recognition to term multi-origin for international trade. This is also not being denied. Then, my lord, paragraph 33. That the petitioner states that the notification dated 22nd issued by Deputy Chairman T Board and Licensing Authority is a ministerial proceeding. And such ministerial proceedings cannot have any statutory force and binding on the petitioner and his foreign clients. But I just pause it, my lord. First, I had challenged this as a notification. Thereafter, I had said this that this cannot be more than a circular. And thereafter, I had said this that circular cannot amend the law, statutory laws, because circular are not issued in exercise of statutory powers, and it cannot amend statutory laws, and therefore it is also bad in law. This is also not being denied. And in fact, the other side, while starting with this, they first said notification. Then they say this is not a notification, this is an administrative matter. After we pointed out in the reply, Article 77 of the Constitution of India, which requires interdepartmental and vetting by the government for issue of such notification. But this I just read it. And such ministerial proceeding cannot have a statutory force and binding on the petitioners if only it cannot conflict with substantive provisions of customs tax, foreign trade, international law. Later does not have non-obstante application. Trade notice is liable to be quashed and set. Now, my lord, we kindly see the affidavit in opposition which we have filed. Is this the paragraph 33 is in paragraph 9, page 10. It was just deny that I just mentioned. I say that I retain myself to dealing with film, etc. Is that general? Then if one of the can we see the page 8, paragraph 8. This with my other paragraphs 23, 39, 41, 28, and 33. These two covers all that paragraph. 28, this it would be which read it with this at paragraph 8. As denying dispute the statement made there is state and active over the matter or I think disappointing to see it would be crystal clear that petition will start damaging the face of India in international market by exporting multi-origin thereby labeling it. This there is no corroborative material any complaint from department. Plain false statement. And one thing I had stated was this that we are not selling to the consumer. Sometimes it happens that a law is made for educating the consumer, just like our labeling act, where in the cartons number of calories, grams, etc. are being mentioned. When we are selling it, we are selling to an expert who first examines this good, says this good, and only after it is passed to their level and matching, thereafter only it can be accepted. And in case of a dispute, international law and dispute arises. So it is not a matter where educating a client can also do this, that if I can supply a bad quality tea by labeling it as a good quality, this is not a person buyer, is not a person who a consumer. He himself is a country or a dealer, sometimes country import, sometimes the institutions import, and they sell it in their own place, etc. It is not a retail. So this is not a case where they have been educating or no. Why? What they have been done is this, that this by this process they have all stopped this transaction because let's put the they said that all others are doing. I said this, it is impossible. No one can do it. Show some instance that how it can be done. This is the form of the Customs Act, which is to be filed. State of origin of the goods, file it on the right hand side. State of origin of the goods. Then, my lord, the countries of origin, they are taxpayer options. There is these are options. All these are places. These are only options. If I don't fill it up, my export processing will be done. It will be stuck. And if I put it, suppose something different, it will be processed. And then what will be? It will be a misdisposition because it is not tallying with my income. If it is not tallying, then it is. I was asking my learned friend, who is complying with, give us some instant complied with. We wrote a letter also, the suppliers copy. Anybody has been compliant, annex it in the affidavit, nothing. It is something which is impact. If state of origin, if it is not being put multi-origin, if it is not an option, how one can describe and declare multi-origin in the system, it is impossible. So in the beginning, I have used somewhere or person we have said these days that what we say is हमने तो जिसको देखा उसके that's high. This was the evidence that वो बगैर करता था all. This is what the kind of the thing which they are making out is this, that there are others who are complying with this, which cannot be done. It is not an educative purpose. All details are very much there in the body of this blended goods, etc., percentage, everything. Whether anybody is buying only by seeing this description or buying with that. So, or country of origin which is required as per law. Under the T Act, there are two categories: wholly produced, not wholly. There is no third category. How they create a category, this was all illegal, and that is the third point was this. And another point is this, which I was closing with this, that very recently I came across very recently, in 2025, I came across a judgment of the Supreme Court. That Supreme Court said that sometimes that time you're relying on new judgment and documents. Have to follow on Mr. Tiwari. Mr. Tiwari will then have to deal with it. No, but this form also form I have given. Yes. Yes, I will have to hear them on this also. Yes, sure. Well, this judgment is in the line of this, that if some procedures are being unnecessarily put, the T board is not doing anything addition to in the matter of export. Entire export is being run by the custom authority who operates the law. PPFP is the licensing authority who issues the licenses, etc. They are now the principal. It's not different. Now, we said is that entire thing, I have to get a document signed by them without which I can't accept. This is something which a busybody will do. Is it irrelevant? Is it putting some value addition, etc.? If there is nothing by that proceeding can be squashed by the court. That is what this judgment is, where the Supreme Court has squashed it from Harsh and High Court, where all the registered societies were required to get themselves registered under some authority for the purpose of the charm that's available. And Supreme Court held that entire proceeding is not necessary and it is unnecessarily excised only to create a layer of secretarial things and for which the entire thing should be squashed. When we kindly see this page 7, 6 line, this is really what now the Rich Court have to do. In view of now the present scenario of a ministerial proceeding, where the courts are only guardian of the public law, this thing, if it is not done, my lord, the T Act, who has no contribution in the matter of export, can do havoc. Last 30 days, no export, nothing on their scale. When their server is brought down, no export is being done. It does not matter to them that our country is exporting this. They are not the part of India. They are not. You know, can you see this judgment? It was very appealing to me. Paragraph 9. Case 6. Administrative law has well recognized the principle of an administrative decision becoming unlawful if the decision fails to take into account relevant considerations, or even when it takes into account irrelevant considerations. Judicial review of administrative action on the ground of illegality would then require consideration of the provisions, statutes, rules, regulations, or even a policy empowering exercise of such power and discretion. This power may be a simple case of interpretation of law. However, as judicial review is in the vein of public law, constitutional courts have the duty to ensure that the power of discretion is exercised in furtherance of the purpose and object of the statute, the rule, or the regulation, or for that matter, implementation of the policy. Well, the policy is under the T Act, Customs Act, Foreign Trade Policy, that is. In the process, while accounting for relevant and irrelevant considerations that may influence the decision, court also take into account the broader principles of rule of law and good governance. Irrelevant considerations including insistence or performance of acts or submission of documents which neither have relevance nor are the value additions to the purpose or object of the law or policy in place. Instead, they are demonstratively superfluous, unnecessary, consuming limited time and human resources. This also has a direct bearing on efficiency and good governance. It appears to us that benefit granted to a cooperative society under 9A of Bihar Amendment is thought to be regulated by the Principal Secretary of the Department of Registration to ensure that benefit is not misused by what he terms as a fake society. With this objective, Principal Secretary, in exercise of his power and direction, directed all registered authorities of the state not to register a document till recommendation of the Assistant Registrar of Cooperative Society is obtained. It is this endeavor of the Principal Secretary that this subject is of judicial review. We will examine the legality of this. Then, my lord, paragraph 12 is that he deals about the requirement of this, that what it is, that and that requirement of a recommendation of the registrar is a precondition for registering and this. So what I'm closing with this, that no purpose objective has been achieved. I demonstrate everything which will come out from a word which is coined by them as a multi-origin, which does not exist. It does not exist in the statutory law, Mother Act, Tea Act, Custom Acts, and all acts which govern. It is being coined to disrupt the entire movement of this machinery, and so that all falls, and they can do something by which Indigo fails, others fare go up to 1 lakh for Kolkata to Dhanbad. So this is what the desire of this. You spoke this, bring it down, and this. So no purpose. Person who will be, suppose my reputation is diminished, if any buyer and seller in a commercial transaction buy and sell goods on the basis of prerequisite requirement. I want A to this level, B to this level, C to this level, and it should be accordingly. It is not on the personal risk. So, but this is no purpose, no objective, and therefore
So Pilari will have to answer this. When can you come? You have only 2 days. 3 days. Third day you can ignore. Friday. Friday will be.
what submissions I made, I have put it on paper on what little bit of this I can just. Not the whole of that. Very good.
My lord will kindly give me a hearing, my lord, because lordship did not. My lord, I will not be able to deal with the points of law raised by my learned friend. My lord, that lordship will, whenever lordship is hearing it next, kindly give me for 2 minutes only on the law part of it. My lord,
How can you maintain your application?
my lord. First is, my lord, the judgment cited by my learned senior friend have absolutely no application to the facts of this case. Service jurisprudence is an entirely.
The fact of the case is one thing. How can a trust file an
My lord, it's been done, which is why it has been done by the Secretary General. So what happens is, lordship, it has to be done by a functionary, which is how it's been done. Well, there are 2 ways of writing it. It may be Secretary General for the Tea Association of India. It could have been Probir Kumar Bhattacharjee, Secretary General on behalf of Tea Association of India, or Tea Association of India through Probir Kumar Bhattacharjee. Well, this is the trustee, the Secretary General, who has been authorized by the trust to file this proceeding, which is an acceptable mode, be it a society or the trust.
The bylaws.
My lord, I have annexed the bylaws. My lord, may I show from the affidavit of competency? My lord, it's been filed with the Vakalatnama. Lordship will kindly see the extracts of the minutes of the Tea Association of India.
From the bylaws.
My lord, kindly.
Minutes are neither here nor there.
My lord, kindly will see Annexure A. That starts at page 13. Lordship. My lord, 72 at Lordship will first see page 32, Regulation Rule 63. My lord, that is the association page, my lord, 32. Page 32. Yes. My lord, first is the association shall have a Secretary General, a Secretary and an Assistant Secretary. The Secretary General of the Indian Chamber of Commerce, Calcutta, shall be the Secretary General of the association. The committee of the association shall appoint the Secretary and Assistant Secretary. Now, Lordship will come to page 33. The Secretary General shall be the administrative head of the Secretariat of the association. Yes.
There is the authority to institute.
What happens is, it is usually always what is
usual, sir.
May I, that lordship, may I come back and try to persuade my lord? I will come back with the regulation. But if lordship wants, then kindly allow me to place it right now. Then I'll place the entire rules and regulations. I'll try to satisfy.
Rules and regulations, you don't expect the court to read the entire rules and regulations. They have to pinpoint where it is. It cannot be everywhere. Don't make these kinds of fantastic.
There are 2 kinds.
It has to be one way.
Lordship.
It has to be at one place saying that this person is authorized. It cannot be everywhere around the world. Everywhere around the world.
May I try and satisfy my lord? There are 2 ways of
this. One is you
Don't
have
try
the.
to hoodwink the court by
Malad,
saying
I'm
that
not
you
trying.
want
I'm trying to
the
answer the
entire,
question.
therefore I'll have to-
Malad will give you
That
an
is
opportunity
not
of
the
answering
way-
the question.
Sir, that is not the way to answer the question.
Malad,
Before that I'll place therefore the entire, therefore I'll read the entire constitution to show that there is one article which can prove the case. That is not how
Malad,
it is.
kindly bear with me for a minute. I was trying to make
I
my
was
point.
dealing with you for so long. This is something which I have not taken.
Malad, may I try to
In good
what?
humor.
Malad, kindly.
Don't place your case as if it is.
Malad, I'm
everything
not.
can
I'm
be
just trying to
proved.
answer my lord's query, my lord.
Don't try to bulldoze the court.
Malad, I'm
have
just
something to say.
Malad, I'm just
Say
trying
that.
to answer the court.
You did not answer my
Malad,
question.
I was Malad, I did not Malad, I was in the process of answering it. All that I'm saying is, Malad, if I
take me, you said
Lordship.
you'll come later on. Then you say I will place the entirety of the rules and
Malad, will bear with me for 1 minute. May I try and explain what I'm trying to?
bear you for
Malad,
many
Malad,
more-
1
many
minute,
more
my lord.
minutes than 1
Malad,
minute.
I have not been able to explain myself. It's my. I apologize, Lordship. I have not been able to explain myself.
You have
Malad,
been able to explain yourself. You failed to explain.
Malad, I
yourself.
have not been able to. Malad, kindly give me a minute, Malad, at least to make
You are
what
not
I'm.
even allowing the court to finish the sentence. You are
I apologize, Malad. I apologize. Malad, I apologize.
This is not how you place your.
Malad, I
If
apologize.
there is one regulation which you want to place, you be ready with that regulation, pinpoint that regulation. If you are not ready with the regulation, take time, pinpoint it on the next day. That is not the practice of this court. At least we have not learnt it that way when I was a few months back on that side, that I would say to the court that let me read the entirety of the rules and regulations. You
Malad, I'm not. I did. Malad,
you waste half an hour because the council is unprepared.
Malad, I
This
did
is
not say
how
that.
you
Malad,
do.
I did not say that. Malad, may I?
You
I can.
said that exactly.
Malad, I said I'll place the entire regulations.
Why
with
should
the-
you place the entire regulation, sir? It has
Malad,
to be
not
one regulation where there will be an authority given to the person to institute suits or
Lordship, may I try and at least answer this question, Lordship? I kindly
what
bear
are
with
you
me.
doing, sir? All these
Malad, this is
minutes.
Malad, this is I'm not doing this, Lordship. Malad, kindly accept it when I say that I'm not trying to hoodwink the court. I'm not trying to misguide my lord. I'm simply
You will
trying
not
to.
be able
Malad,
to do that, sir.
Malad, I'm not trying to do
However
that
much you
even.
try,
Malad,
you
I
will not
know,
be able to
Lordship,
do
Malad,
that.
we
You will
hold
not
my
be
lord
able
in
to
very
do
high
that, but
regard.
then-
I did not even try to do
but
that.
then I took exception to this that I will, and then let me place the entire
Malad, I did not mean it that way. Malad, there are several.
Sir, you have wasted 4-5 minutes
Malad,
on
at
this
least
only.
may I
You are
complete
going
one
on
sentence,
arguing
Malad?
on this. This is not going to
Malad,
take
as
us
my lord
anywhere.
pleases, my lord, as my lord.
It's up to you. Up to you.
Malad, as my lord.
Up to you.
But I'm merely trying to say that from a reading of several clauses
It's up
in the
to you. You have made
regulations.
up your mind not to make submissions. Up to you.
But that's what.
So, sir, again, I'm saying, please don't hoodwink the court by these
But
practices.
I'm not trying to hoodwink the court. But that's what I'm trying to.
So don't say this. As my lord pleases, you'll close the book and then you will start again. Stick to one stand.
But my stand is, Lordship, kindly grants
Then
me
please
1-2
come to the point.
sentences.
Show me the regulation.
Lordship.
Yes.
Malad, first
don't try these practices here.
Malad, may I at least answer my question, Lord's query? Malad, the first is.
I've been waiting for you.
Lordship, because I have not been able to finish the sentence, my lord. If Lordship gives me that minute, my lord, I'll try and explain what I'm trying to say.
5 minutes answer the question.
Lordship. First is, Lordship, there is no particular clause in the regulations which specifically deal with this point.
Wait, please wait here.
Lordship.
If there was no particular clause which deals with this, why did you want me to take? Why did you want to take the court through the entirety of the regulations? Just
Malad,
5 minutes back?
I meant the entirety of the regulations to show, just as I placed clause 62 and 73, I can place several other certain clauses, a joint construction of which will lead to the conclusion that it is the Secretary General of the organization.
I'll waste entirety of half an hour. Let us see whether we can find one such clause which will empower you to file a suit or a proceeding upon a cumulative reading of the entirety of the regulations. Please show that. Please take me through the entirety of this. We are at page 13. Start from page 1. I mean article 1.
Malad, we'll first see. I will not come to the objects as to why the tea association is relevant. I'm leaving that out, Lordship. I'm then coming to. Lordship will kindly come to page 13, 3, 4, and then 5. The association the association is to consider all questions connected with trade, commerce, manufacturers, agriculture, plantations, and industries, and to initiate or support necessary action in connection herewith and in particular of T. So the first task of the association is that it is specifically formed to initiate necessary action in case of issues affecting its members. Then the next is 5. It says that it can advise and render assistance to the members of the association and others on all questions connected with trade, commerce, manufacturers, etc. Now, my lord, 7 is the one which is relevant for us here, to promote or oppose legislation and other members and to procure change of law practice affecting trade, commerce, agriculture, and in particular tree. Now, lordship will come in light of this, page 18, and that is sub rule 40. To represent members of the association before industrial tribunals, tea board, government, municipal, local authorities, other public bodies. And lordship, lastly, 43 on page 19. Is to do all other lawful things that are incidental or conducive to the attainment of the above objects or any of them. Now, my lord, this is the reason for which this particular organization has been formed. Now, by itself being a registered trust, it can only take all these measures if it proceeds before, if it has to oppose a legislation. It would have to intervene in that legislation either as a party or through other means. For instance, we have filed the intervention application in a proceeding filed by other stakeholders of the same industry. In order to give effect to this particular objective, the association has to argue and appear in a certain form through somebody, through an office bearer, which is lordship knows in case of, for instance, the Societies Registration Act. There also what happens, there it will not do it by itself, but under section 19, it can do it through either its secretary or president or any other office bearer who has been authorized in that behalf. Now, similarly, it would also be the same case with respect to the trust as well, where there would be a certain number of office bearers for any action to be taken on behalf of its members who are the tea growers. It would have to move through a functionary, because it can't do it. It cannot be Tea Association of India having its registered office at such and such. It can only be the office bearer who is approaching this honorable court on behalf of the tea association, and that person would have to be authorized. Now, my lordship very rightfully observed that if it were usually in most such organizations now, the rules provide that the president shall be the person competent to represent the association in all legal proceedings. In that case, simply by showing the rules, the president would be then able to, in this case, had there been a clause like this saying the Secretary General will institute all proceedings. Now, in that case, it simply could have been filed, the Tea Association of India, through the Secretary General, and when lordship would put this query to me, all I would show would be this clause. Now, lordship, in the absence of any such clinching clause, which could be the case with any other organization, especially this, because this happens to be a very old organization, lordship will see that it was formed more than 60 years ago. Which is why what has happened is, lordship, the office bearer has been authorized by the committee of the tea association. Lordship has seen that the committee shall be taking all the necessary steps. Now, the committee has to move through somebody, through an agency, in order to represent its case before your lordship, which is why it has authorized the Secretary General, who has filed this intervention application on behalf of the Tea Association of India. Now, my lord, the judgments in this regard cited by my learned senior friend, my lord, one such case I am aware of, at least in the case of service jurisprudence, the law has significantly changed since then. In fact, similar associations can now institute proceedings in its own name. In fact, even if it is not, it can do it through its secretary or president or any other office bearer authorized.
There is a basic difference between any other kind of association and a trust. Trust has a definite definition in law. Trust is only an obligation.
Lordship.
whether an obligation can come up before the court without the trustees being a party to the proceedings is
Lordship.
something which we are required to answer.
Lordship.
The trustee can, if
Lordship.
the trust deed or the instrument of creation of trust
Lordship.
reposes such power in the trustee,
Lordship.
for the trustee to
Lordship.
come forward on behalf of the trust,
Lordship.
or all the trustees will have to give that power to
Lordship.
some other person who can represent the trust.
Lordship.
This was the only question which you are required to answer and which was put to you, which is yet to be answered.
Malad, for that, if Lordship kindly sees the extracts, the authorization given by the trustees to the Secretary General to institute this proceeding. Malad, that is with the Vokalatnama, I believe it comes in the form of the competence. Sir, sir, I've not. Let me first be added, sir. I'm sharing my copy. Let me place it. I'm giving it. Malad, may I place it, Lordship? Extracts of the minutes of the Tea Association of India held on 19/8/2025 at 4 p.m. at the registered address of the Tea Association of India at India Exchange such and such. Whereas, as per the rules and regulations of the association, the Secretary General is the chief administrative head of the association and is empowered to deal with all affairs of the association. Resolved that Mr. Probir Kumar Bhattacharjee, Secretary General, is hereby authorized to act on all administrative
Whose
matters on
resolution
behalf.
is this? It doesn't appear to be one of the trustees. I mean, resolution by the trustees.
Malad, it's by the President, Lordship.
Minutes of the Tea Association of India. The minutes, meeting of whom? Meeting of the trustees. Who met to take this resolution? Who adopted this resolution?
So there will be people who must have attended the meeting. Malad, in that case, Lordship, I must apologize because I will have to take instructions and get further documents. Malad, that is the only submission. I apologize for what has come to pass, Lordship. Sir, you also not. Sir, if there is any affidavit,
If you are reading the device,
yes, sir, this is my original. Yes, yes, please.
Heard Mr. Mehta, learned senior advocate, appearing for the petitioner in reply. Full stop.
ये फोटो लेते हैं उधर से
Mr. Sarkar,
फोटो लेना
learned
अरे क्या
advocate,
फोटो
appearing
लेना है
for the applicant GA1 of 2025 submits that the applicant's rights would be affected if any order is passed in this writ petition in favor of the petitioner or against the petitioner. Your rights would be affected how?
Malad, if the notification is struck down, it will affect me.
If any order is passed striking down the notification that has been challenged by the petitioner in this writ petition, full stop. Paragraph, Mr. Mehta, learned senior advocate appearing for the petitioner, submits that the application being GA1 of 2025 that has been filed by a trust is not maintainable. Full stop. Mr. Sarkar, learned advocate appearing for the respondent, seeks time to demonstrate that the application filed by the applicant trust is maintainable before this court. Full stop. List this matter for further consideration. When will Mr. Tiwari come? Tomorrow he can come. Tomorrow.
Malad, kindly accept my abject apologies.
Not at all. No apologies needed.
No, Lordship, I
but be
apologize.
cautious when you.
Lordship. Malad, I'm
there
sorry
has
if
to be
Lordship got
some-
that
There has
impression.
to be some kind of. I'll stop from saying anything else. But
Malad, I'm unconditionally apologizing. Lordship,
Not
if
at all, not
Lordship
required.
taken amiss at any of my submissions or the way I put it. I apologize. Sir. Grateful.
politeness does not cost anything,
No.
but it takes you a notch higher.
Lordship, I apologize. Grateful.
You may be very knowledgeable, you may be very high, but then there are certain, but there is no harm in being polite.
Lordship.
Lordship.
When I closing the two lines in Urdu, my lord, which is being said, सच घटे या बढ़े तो सच ना रहे और झूठ की कोई इंतहा नहीं.
Next.
Lordship, I'm appearing on behalf of the petitioners, Your Lordship. Lordship, I was praying for an adjournment because I'm being led by Mr. Orijit Chakraborty. Due to some personal difficulty, he's unable to come appear before this honorable court. So, any day after the vacation, if that's possible, Your Lordship.
As prayed for by the learned advocate appearing for the petitioner, list this matter on January 5, 2026.
Item number 12 is also arising out of similar impugned order, my lord. Same impugned order.
Like 11.
Like same impugned order.
Same order for 5th January.
12. 12. 12.
Same order. January 5, as prayed for by the learned advocate appearing for the petition.
Adjourning.
Yes, he sought for an adjournment.
11 and 12, both.
Careful. Item number 30.
You'll conclude today.
My lord. I'm hoping, my lord.
15 minutes per day.
I have placed the main decision. I now quickly just show the relevant portions only of certain decisions, man. If my lord, if it's convenient for my lord.
Yes, of course. It's always it's my duty. I have to hear. I'm here to hear.
No, if he cannot conclude today, my lord, then again it will be taken up on next day. So I would suggest, my lord, if he can conclude today, then let's.
13-15 minutes you should because you are in reply, so it won't be.
My lord. But I have shown to my lord the principal decision. Now, my lord may kindly take signature. But the proposition, if I may just briefly, just recapture the proposition I was making on the previous occasion, that my lord, it is a jurisdictional requirement for the department to have in its possession information, and my lord, that information needs to have a nexus with escapement of income and the reason to believe that income chargeable to tax escape assessment for the purposes of assuming jurisdiction. My lord. So, although the sufficiency of the material cannot be looked into, but my lord, that nexus has to be established before my lord jurisdiction is assumed. Now, my lord, there are other decisions, my lord, of the Honorable High Courts, wherein your lordship, the decision of Lakmani Naval Das has been followed, but in red jurisdiction.
Yes, you had cited last time.
But Lakmani Naval Das I cited, my lord.
Yes.
This is the decision of the Honorable Delhi High Court of signature itself.
Following this.
In writ jurisdiction, because even Lakmani Naval Das is a matter arising out of writ jurisdiction, your lordship. I would may kindly take paragraph 5, my lord.
Paragraph 5.
Yes, your lord. Your lordship, in paragraph 5 and paragraph 6, my lord, the decision of Lakmani Naval Das has been referred to. And thereafter, my lord, from paragraph 14, your lordship, the principle has again been laid down by the Honorable Delhi High Court, referring to the aforesaid decision, wherein my lord, if my lord sees paragraph 13 once, my lord, that paragraph 13, that information has been given. So, my there is actually some data. So, if I may say, if I may use the word, it's paragraph 13, my lord. At page 558, my lord. So there was some annexure that was provided with respect to the transaction in that particular matter, your lordship. Your lordship, and that particular data, in fact, spelled out what the nature of the transaction was, which was not even spelled out in my case, my lord. And thereafter, from paragraph 14 onwards, my lord, the Honorable Delhi High Court,
yes,
on the basis of the principle, has held that the first sentence of the reason states that information had been received from the Directorate of Income Tax that the petitioner had introduced money accounting to rupees 5 lakhs during the financial year as per the details given in the annexure. The said annexure reproduced above relates to check received by the petitioner on October 9 from such and such from the bank account, number such and such. The last sentence so therefore that information has been mentioned thereafter from paragraph 15. The aforesaid reasons do not satisfy the requirement of section 147 of the Act. The reasons and the information referred to is extremely scanty and vague. There is no reference to any document or statement except the annexure, which has been quoted above. The annexure cannot be regarded as a material or evidence that prima facie shows or establishes nexus or link which discloses escapement of income. So this is the principle I want to show and show before my lords, that while it is absolutely necessary for the department to have information in their possession and establish the live link. In my case, if my lord may recollect, my lord, that the annexure given by them talks about Reliance, does not say the nature of the transaction. They are referring to one case-related information details, my lord, where the source name is Reliance. Details are not mentioned. Then they refer to this investigation wing report. The report does not mention my name. It is only in one of the ledgers attached to the investigation wing's report, which was also in the name of Reliance General Insurance Company. List of large vendors, there my name features, and one of the intermediaries of Reliance, with whom I have no nexus or connection, there the name of Prudent is mentioned. So no nexus has been established. My lord, my lord, if I may also show one decision of this Honorable High Court in the case of Prashant Desai. Now, this is an appeal, but my lord, that even our Honorable High Court was pleased to follow the principle, or if my lord, actually, given the paucity of time, my lord, I just thought I'll just indicate.
No, please.
Karan Maheshwari. My lord, may kindly take para 6 onwards. My lord, at page number, last page, my lord. In this regard, my lord, paragraph 6 is. In this regard, it would be beneficial to refer to the decision of the Honorable Supreme Court in the case of Income Tax Officer versus Lakmani Mevaldas. In the said decision, the Honorable Supreme Court held that reasons for formation of belief must have a rational connection with or relevant bearing on the information on the belief. Rational connection postulates that there must be a direct nexus or live link between the material coming to the notice of the income tax officer and formation of the belief that there has been escapement of income and the assessee of the assessee from assessment in particular year because of this failure to disclose truly and fully all material facts. It was further pointed out that the court cannot go into the sufficiency or adequacy of the material and substitute its own opinion for that of the income tax officer on the point as to whether action should be initiated for reopening assessment. However, at the same time, it must be borne in mind that it is not any and every material, howsoever vague and indefinite or distant, remote, and far-fetched, which would warrant the formation of the belief relating to escapement of income of the assessee from assessment. Therefore, section 34 has been referred to, which was there in the 1922 Act, which required definite information, which was deleted. And noting that, the Honorable High Court says that referring to section 34 of the Act, it was held that the words definite information which was found in the said provision is not there in section 147 of the 1961 Act. And this would not lead to the conclusion that action can now be taken for reopening assessment, even if the information is wholly vague, indefinite, far-fetched, and remote. It was held that the reasons for formation of belief must be held in good faith and should not be a mere pretense. The decision of the Honorable Supreme Court would squarely apply to the facts of the instance case. And this principle, therefore, has also been followed by the Honorable Division Bench of our High Court to quash reassessment proceedings. Now, my lord, I'll now, my lord, take my lords through one decision of the Honorable Bombay High Court, case of Karan Maheshwari, wherein your lordship, after this new regime of 148A was introduced, My lord, this same principle has been applied by the Honorable Bombay High Court. But in case of 148A proceedings, to quash the proceedings, my lord, because of the absence of that nexus. As paragraph 18, my lord. But it is settled law that reasons for formation of belief that there must be escapement of income must have a rational connection with or relevant bearing on the information. Rational connection postulates that there must be a direct nexus or live link between the material coming to the notice of the income tax officer and his view that there has been escapement of income of the assessee from assessment in the particular year. It is settled law that not any and every material, howsoever vague and indefinite or distant, remote, and far-fetched, which would suggest incomes, which would suggest escapement of the income of the assessee from assessment. The powers of the income tax officer to reopen assessment, though wide, are not plenary. The Act no doubt contemplates the reopening of assessment if grounds exist for believing that income of the assessee has escaped assessment. The live link nexus should be there between the information before the income tax officer and the belief which he has to prima facie form an opinion regarding escapement of income of the assessee. It's been applied, my lord, even to 148A proceedings. And my lord, there's another decision that I would take, my lord, Kelvinator of India. My lord, ओनर केसेस जेटा हम देखते हैं सब वो जो किया तक नहीं केसेस ये इशू in this decision of Calcutta of India, my lord, yes. Paragraph 6. Now, this is a celebrated decision which lays down the principle of change of opinion. But in the middle of that paragraph, my lord, it says that the power of that. I want to just highlight two facts, my lord, from two principles. That the power given is of reassessment, not of review. Secondly, my lord, the assessing officer must have some tangible material to come to the conclusion that income chargeable to tax is escaped assessment. But the ninth line from the bottom of at page 564, it says, hence after 1st April 1989, the assessing officer has power to reopen, provided there is tangible material to come to the conclusion that there is escapement of income from assessment. Paragraph 6, Your Lordship. Yes. But so he doesn't have the power of review, because if I may indicate, the power of reassessment is actually a very strong power given to the department, because once the reopening is done, the reopening is done, my lord, the entire assessment becomes at large. So therefore, it's not a small power. It's a very strong tool given to the department, because then he can, once reopened, my lord, validly, he can go into any issue. He can investigate anything. So therefore, my lord, there needs to be checks and balances on this power. My lord may now take section 148A, my lord, once. That's section 148 and 148A. I'll first disturb my lord with section 148A, subsection 1, my lord.
On 48A1.
It says, the provision says where the assessing officer has information which suggests that income chargeable to taxes escape assessment. In the case of an assessee for the relevant assessment year, he shall, before issuing any notice under section 148, provide an opportunity of being heard to such assessee by serving upon him a copy of the by serving upon him a notice to show cause as to why notice under 148 should not be issued in his case, and such notice to show cause shall be accompanied by the information which suggests that income chargeable to tax has escaped assessment in the case for the relevant assessment. So, my lord, it is the requirement of law that existence of information having a nexus has now been codified. And but even section 148, my lord, the first proviso to section 148. My lord, it says, provided no notice under this section shall be issued unless there is information with the assessing officer which suggests that income chargeable to tax has escaped assessment in the case of the assessee for the relevant assessment. Well, existence of information is a mandatory jurisdictional requirement. And my lastly, well, my learned friend made the point that I can't come to this honorable writ court. Right? If I humble submission, your lordship, firstly, section 140, the order passed under section 148A3 is not an appealable order. So I have no remedy but to come before my lords. And the case law relied upon him of the Honorable Jharkhand High Court, that was a case where the person had come against the notice under 148A. It wasn't a case where the person had come against the order passed under section 148. And nonetheless, there is a decision of the Honorable Supreme Court in the case of James Nick. This is a very short decision. Actually, I mean, just very short, brief background. And what had happened was that earlier, when 148 notices were issued, the assessees would come before the Honorable Courts in a writ petition. The Honorable Supreme Court, in the case of calculated discount, held that the writ petition was maintainable. Subsequently, Your Lordship, there was one decision of the Honorable Supreme Court in case of HON'BLE Das. In that case, my lord, the assessee had come after the 147 order was passed. In that case, the Honorable Supreme Court held that you cannot come to the court directly. And my lord, even in the interim, my lord, the decision of GK and Direct Act was passed, which allowed that, which in fact mandated what is now codified in section 148, that you give reasons and file objection, order is passed. Now, this on decision of the Honorable Supreme Court clearly holds that writ petitions are maintainable against the notices issued under section 148. So my writ petition is very much maintainable.
And what about the factual point which he took that from the chart, the name of that Prudent or something, no? Prudent's name appears, and that shows that some money had gone to you from Prudent.
That is if I only kindly see the chart, please 158. What was actually 158?
Yes.
This chart is a part of the investigation wing report, which does not mention when. Now, this chart itself, my lord, I would kindly take the top of the page, my lord. It says Reliance General Insurance Company. So therefore, it is.
Where does the report begin?
My lord, the report, my lord, if I may just show the information, my lord, where it begins. I will kindly take page 87. And page 86 is the notice.
Page 87.
Page 86 is the notice. Page 87 is where the information begins. This is my effectively reasons. He says the information contained that the company has made transaction with the following insurance company, thousands of intermediaries, during the year under consideration, which is not in accordance with the provisions of IRDAI. He says Reliance General Insurance Company Limited, rupees 1 crore 9 lakhs. And then he doesn't say what the nature of the transaction. He says the foregoing information suggests income chargeable to tax escape assessment. Now, my lord, the next page, next is my page 89. Yes. Now, this is the case-related information given to me online. But this has been uploaded by the investigation wing, Your Lordship. My lord, this case-related information at the middle of the page, my lord, there is information details.
Yes, yes. That this you had shown.
Those no data available, my lord. Thereafter, it talks about Reliance General Insurance complete data. Now, then the investigation wing dissemination report starts at page 91. But the report talks about search and seizure on middle layer business entities of insurance sector was conducted on 30th November 2022 by Investigation Unit Mumbai under names Wings Brand Group and Ajay Mehta Group, respectively. But I have not named anywhere in this report. But after that, the department has provided one chapter 28, which is a part of that report at page 100. This is all the data given to me, and I'm calling it data by not information. Page 100 is again the chapter on Reliance General Insurance Limited. It does not mention my name anywhere. After that, my lord, at page 128 are the statements. It does not mention my name anywhere. And my lord, recollect, my lord, the decision of Lakshmani Vevadas clearly spelled out that where there is no name given, just because I entered into the transaction, Lakshmani Vevadas, the allegation was that there are transactions between me and the petitioner therein, and my lord, certain persons who have admitted that they are entry operators. There was clear transaction between them. But the court held that that is not enough for initiating proceedings under 148, 147. It is without jurisdiction. In this case, Your Lordship, there is no data, no statement anywhere against me as well. In fact, there is no transaction. Department has not produced single evidence to show transaction. After the statements, my lord, the department's documents start from page 154, the ledgers. My lord, will kindly see the data at page 154 is details of, well, it's again for Reliance General Insurance Company Limited. It says details of large marketing vendors during financial year 17-18 and then is 18-19 as well. Well, it is marketing vendor. I am a marketing vendor. There is no dispute about that. And well, the next column is name of insurance intermediary. How does it show that I have a transaction with that intermediary? It simply shows I have a transaction with Reliance General Insurance Company. I have not disputed it. I have given him data with respect to the same. He's not dead with my data, but he goes on prudent. Well, even in that page, the word prudent is mentioned, but for assessment is 70, financial 17-18, there's no proceeding against me. Similarly, page 158, which my learned friend was relying on, it says details of large marketing vendor of Reliance General Insurance Company. I am a vendor. That does not mean anyone who's transacted with them has entered into some kind of a fraudulent transaction or accommodation entry. And it says nature of insurance intermediary. That is prudent. It is his intermediary, not my person. And my lord, I've also annexed, I've taken my lord the liberty, my lord, to annex a copy of the invoices raised by prudent, which is the page 287. I've shown it my lord at the time of facing my arguments earlier.
This was given to the officer. These documents.
The allegation of prudent comes for the first time in the order. And my lord, now if I may make one last submission, Your Lordship, that today the basis of the notice was Reliance General Insurance Company. If the basis goes, my lord, the notice goes. If prudent is their case, if the law allows them to issue a fresh notice, they can. If the law doesn't permit them, limitation bars them, it's gone. But my lord, I have no transaction. And lastly, my lord, my learned friend had said that just because I'm a central government PSQ, that I'm just another assessee. In my humble submission, I'm not just another assessee. Because my lord, it is well known that public sector undertakings, my lord, they undertake projects and my lord, objectives which general commercial, no one is having commercial students would enter into. But my lord,
I'll keep it one more day to wrap up. I'll go through the documents, and if necessary, I'll conclude hearing then. Heard Mr. Janwala, learned advocate appearing for the petitioner. Full stop.
देगा डेट फिर से इस सोच के मिला
कितना देर
20,000
Humble submission. Humble submission.
Yes.
My lord, on 27th of November, my lord was pleased to extend an interim order, and I had to appear through VC. I was in Delhi at that time. My lord was pleased to say that if I can initiate the case or the proceedings or the hearing on that day itself only, but my lord was pleased to extend the order with the liberty to the matter to be appearing in the list itself. My lord, yesterday, what has happened is respondent number 5, Asansol municipality, they have issued a new bill, which was the act of the petitioner itself, and they are threatening to disconnect the water connection of 1100 flats.
1100?
1100 flats.
No, this matter pertains to which determination?
RERA, my lord.
RERA?
It is listed
hearing
in
matter.
item number. If the matter can be heard as an urgent matter on 19th onwards.
19th of
this December. Onwards.
December, before vacation, I cannot take up hearing matter. It becomes difficult.
My lord,
If
a date
interim order
be
is there, how can they proceed? What is the interim order?
interim order was interim order, since the interim order is subsisting and is continuing till 28th of November, the same is extended till end of January 2024.
Where the interim order is there, then what is the problem?
I am for the respondent number 2. I am the victim, my lord. I am the association of 1100 flats.
I couldn't get you. If the interim order has been against you and you have not challenged it, then you should have challenged it then.
My lord, we have challenged it. The affidavits have been exchanged.
Interim order challenged it means you'll have to challenge the interim order in appeal before the appellate forum. If you allowed the interim order to remain, now you come up at the fag end of the year when the vacation is approaching to get the matter finally heard at the instance of the respondent. How can that be done now? You should have come earlier then. December, if it was done on 20th of November, you should have come on the 1st of December, 2nd of December.
Intimation was done on 2nd of December.
Sir, the interim order was there.
My
If
lord.
the interim order was pinching, then in that case, you ought to have mentioned it earlier. At this stage, if you mention, how can I take up? You see, what is the stage? If I start taking
I
hearing
appreciate it, my lord.
matters now, it's difficult, sir. There is an interim
If
order
it is
operating.
in the month of January, if a date
Yes,
be fixed,
definitely. I'll fix a date, but not now. How can I fix now?
my lord.